Pronouncement judgment matter pertaining to the Kohima bench, PIL number 2 of 2024.
Petition dismissed.
Adjournment request, if any, item number 1 to 7. Request, if any, item number 1 to 7.
Please, your lordship, I beg to mention item number 2. There is,
Item number 2.
yes, there is bereavement in my senior's family. Kindly adjourn for 3 weeks time maybe.
Yeah. Yes. 2 weeks.
Item number
Yeah.
8 to 20.
Yes.
May I please, your lordship? Lordship, I beg to mention item number 13, as my senior Mr. S.K. Mehdi is out of station. Kindly matter may be taken
Item
up
number 1-3.
1-3.
नाम भी नहीं है.
उनका नाम नहीं है.
Okay.
Name is also not reflected in the copy.
With this matter after 2 weeks, while reflecting the name of Mr. S.K. Mehdi
Lordship,
as counsel for the petitioner.
deeply.
While reflecting the name of the S.K. Mehdi in the court list.
Item 21 to 31.
Please, your lordship. My lord, I beg to item 21, my lord, for adjournment for today, my lord.
Adjourn.
Highly obliged.
With regard to item number 22, your lordship, we have some personal difficulty today, but a matter after 3 weeks, your lordship.
Adjourn. 3 weeks.
Maybe lordship, I recommend item number 27.
Yeah.
Angus counsel Mr. BC is some personal difficulty matter may be urgent for the lordship.
Challenge
27.
27.
Adjourn.
May I please, your lordship? Lordship, I beg to mention item number 29, lordship. Lordship, we need 2 weeks of time to file reply affidavit.
Yes. Dispute post office ये matters आना चाहिए ट्रैफिक जीपी जब ये हुआ ये agreement हुआ नहीं तो जब हुआ देखा कि 7 months का पेंडिंग तो उन्होंने अपडेट करने के बाद इमीडिएटली मालूम पड़ने के लिए वेबसाइट पर तो करने भी राइटली इंटरप्रेट
Adjourn.
Deeply obliged.
Yes.
Item number 32 to 38.
Lordship, item number 35 is a hearing matter,
3-0.
335, lordship.
Yeah.
May be taken up in the second week of November, lordship. Mr. Saraf is also given consent.
Adjourn.
My lord, with of the, my lord, the respondents, senior counsel, my lord, item number, my lord, 38, my lord. My matter may be adjourned today, my lord, for fixed on Monday next, my lord. 28, my lord. Lordship, 38, my lord, supplementary. Monday, my lord.
which means then in terms of
Nothing in this. Leonard Singhal has rightly said. Draw of lottery, how do you want to this by that?
My lord, in this case, my lord, the senior counsel engaged, my lord, can story, my lord, he's some, my lord, today, my lord, personal difficulties, my lord, that is why, my lord, on Monday next week.
In any case, my lord, we have already awarded the contracts.
Monday.
Obliged.
Any other requests? For orders, item 1.
Next is your lordship. This matter relates to my lord, granting of financial upgradation, as per MSCP scheme, my lord. And then that issue has been already resolved by this honorable court, my lord. We have stated in case number 4, the case number WPC 4806 of 2015, that has been dismissed on 19/11/2022.
But you have not taken the steps.
Steps, my lord.
It is listed for that only.
No, my lord, that similar issue has been steps.
30th of September 1994, lodging a court order.
Steps has been taken. I'll check, my lord, for the steps. As per-
But on last occasion, we have already said that if steps will not taken, this petition shall be dismissed without reference to the bench.
Ma'am, I'll check. Can we take after some time? Ma'am?
It has to be dismissed.
Yes, ma'am. I'll check, ma'am. Can we take after some time? Ma'am?
After some time.
After some time. Ma'am.
Item number 3.
May I please, Lordship, in this case, Lordship, the notice has been written answered. It is not that the address could not be located. And as per our record, Lordship, this is a correct address. Earlier, we took steps on Guwahati address. They left the Guwahati address, then we took steps from their Calcutta office address. Lordship.
Now, what is the report?
Lordship, report said that the address could not be located.
Address could not be located.
Lordship, that is the endorsement of the postal authority.
Address cannot be located, then if the address is not located, then what to do?
Lordship, we may be allowed to take the step by publishing in newspaper. Lordship. Because as per our record, this is the address provided by them and that is available in our record logs. Because they are the SEC and in PAN card also there, this address is, both address of Guwahati and as well as Calcutta is reflected. Lordship. Not interestingly, they appeared before the tribunal and notice was served on the address at Guwahati, Lordship. But thereafter they left the Guwahati office.
Now, as per your information,
It is
there's
Calcutta office, Lordship.
Calcutta.
Lordship.
But Calcutta, the address which you have given, it is not, this address cannot be.
Located, that is the,
located. Then
we'll take step by publishing in newspaper, Lord, if your Lordship allows.
52 Western Street, 4th floor, Kolkata. 52 Western Street, 4th floor.
And in
We furnished a proper address, sir. 52 Western Street, 4th floor, Kolkata. Which is that building, 4th floor, which building?
Lordship,
Western Street, 4th floor, street can't have a floors.
that was their address disclosed by them in their PAN card in details. Lord.
In there,
In then PAN card and others. Lord. That is available in the official record of the income tax department.
okay, the notice is issued to the respondent, sole respondent,
Oh, sole respondent.
return unserved with a postal note that addressee cannot be located, full stop. And then council has submitted that. As a matter of fact, the appellants have provided the address of the sole respondent, which was mentioned in the PAN card, in his PAN card, full stop. It is submitted that earlier the whole respondent appeared before the tribunal and the notices upon him was served at Guwahati address
Lots.
only, but now the sole respondent has left the Guwahati and at present residing in Kolkata, West Bengal. Full stop. Learned council has submitted that it appears that the respondent is defined the service of notice issued by this court, and therefore the department be allowed to get the notice served upon the appellant through publication, sole respondent through publication. Stop. Taking into consideration the submissions made on behalf of the counsel for the appellant, we deem it appropriate to allow the appellants to get the notice served upon the sole respondent through publication. Necessary, the publication in the newspaper widely circulated in the Assam, state of Assam, as well as in West Bengal, Kolkata.
Much.
Item 4.
Notice, list up to 4 weeks.
Lordship, we have filed an affidavit causing the dusty service, Lordship.
Just the, where is your?
It was filed on 24.
Was received by his mother. Receipt. The mother of Chandrasekhar.
28 million.
Chandrasekhar.
It was received by his mother in presence of the Panchayat Pradhan and the Lordship Sarpanch. Lordship, he is well aware, his lawyer is pursuing a contempt. He talked to me that, you know, that notice has been. No, he's not the lawyer, Lordship, wrongly named. His name is wrongly named. In the contempt petition, some other lawyer is appearing. His name may be struck off, Lordship.
There was an order on.
There's already an order.
Already ordered, Lordship.
Affidavit is filed on behalf of the appellants, stating that the notice, the notice issued to the respondent Chandrasekhar was served upon his mother in the presence of the office bearers of the Gram Panchayat concern. Full stop. Having gone through the service of through the representative of the local Gram Panchayat concern. Full stop. Learned concept of the appellant has also submitted that, as a matter of fact, the respondent is aware about the tendency of this writ appeal because he is regularly pursuing the contempt petition filed before this court through concept. Stop. Taking into consideration the above facts and circumstances of the case, we deem it appropriate to treat the service of notice upon the respondent Chandrasekhar as complete. This writ appeal after 2 weeks for admission.
Item number 5.
No steps have been taken.
Lordship, in this case, what happened earlier, we took steps that was returned answered. Lordship, thereafter we directed to confirm the correct address. Now we have confirmed the address. They are operating their industry from the same address. Lordship. So I may be allowed to take the service. Lordship.
And the concept of the petitioner, applicant has submitted that the proper and correct address of the addressee, address of the respondent has now been procured, and the same procured, and therefore some time may be granted to file the requisites for service of notice upon the respondent. Full stop. Time prayed for is granted. Requisites will be filed within a period of 1 week on the correct, mentioning the proper and correct address of the respondent. On furnishing the same, let notices be issued to the respondent, returned about 4 weeks thereafter.
Lordship, we may be allowed to take the justice service also.
Registered AD and Dasti.
Much.
Item 6.
notice, you are appearing. for the-
Respondent, my lord.
Okay,
Respondent one.
This is
the officers reported that the notice upon the respondent number one has not been received, answered, received. However, Mr. So and so put in appearance on behalf of the respondent number one. Service is therefore complete. Learned counsel for the appellant has submitted that in identical matters, this court has already admitted the writ appeals. Full stop. Learned counsel for the respondent is not in position to dispute the said fact, hence admit no need to issue notice as parties as a respondent is represented through counsel. Connect with writ appeal number 50
of
2024.
50, no?
Item 7.
24.
Notices have not been served.
no, sir.
You are appearing
My lords, I appear for the respondents number 1, 3, 4, and 5, my lords.
1, 3, 4, and 5. Yes, is the last time.
Yes. Go ahead.
6, respondent number 6.
We have taken step by registrar closely.
Only when it came to-
Await return of notice of respondent number 6 for 3 more weeks. Or 4 more weeks.
Obliged.
Item 8.
My lord. 423 days deal. Notice may go, my lord.
Why?
No, actually, my lord,
You don't know that.
she was transferred from that school, my lord. I mentioned in my petition, my lord, and her mobile number was also changed, my lord.
Appealed it.
Transferred from the school, so how that?
My lord, earlier she was in Dibo, my lord, in the Sivasagar district. Now she is transferred to, my lord, Naharkatia. It is in Dibrugarh district, my lord. So there, and address is also changed, my lord, so we also could not communicate her, and she is also not communicated with her, my lord.
Notice. Returnable 6 weeks.
Item 9.
Yes, sir. This is from- ये आगे वाला एक जरूरी है। Not sir. 16 happens. Same illegal division have taken a different. I don't know. Oh, not sure. A right to information act. Reported as. Sir, page.
Pre-amendment will apply.
127. Sixteen 5%. Different. I was also. ये जो nine.
Right to information.
Right to information. ये नया है सर, ऊपर है, नया 16.5 जो सर ये वाला में था। Then there is nothing given that it will be paid out. And the secretary can will be giving pension on secretary. Have the Arunachal judgment?
Yes, my lord.
Yeah, next year.
It's not a mix.
Not.
For Arunachal and Kerala judgment. That judgment, my lord, they were seeking the state information commissioner, they were seeking the benefit of chief information commissioner.
No, this is the. This one, Arunachal. Final completion is not. And they are not just. One way. And we will be reduced by that venture. Not taken away. The petition this view was taken is predicted, whereas the view taken by the. There is he has not even. बात वाला में बोला है कि that is not applicable because उनका वहाँ पे वो गवर्नमेंट सर्विस गया है. And Kerala government is also even subject to corruption so much पहले पता नहीं था. That this is also the bigger of the in bench.
Yes.
State Chief Information Commissioner has been given the benefit of 16.5.
16.5
Five.
is in respect of pay and allowances.
Pay allowances and other benefits, no?
Other,
Other benefits. Other benefits.
other benefits
Also.
of what other benefits? Pay and allowances, whether pay and allowances include pension,
Pay and allowances and other terms and conditions of service.
that's another thing.
On
Pay
this,
and allowances include pension.
yes, pay and allowances and other terms and conditions of service. Although they, in respect of the central chief commission, that section 13.5 will apply, similar provision. They have got it, my lord. In respect of the central chief information commissioner, they have got it.
Let us see, sir, we'll examine this issue. Having heard the learned concept of the
Although this
party,
is the third, my lord, I only pray, my lord, your lordship will fix a short date.
having heard the learned concept of the party, after going through the judgment passed by the division bench of this portal, which can rebuy and others, as well as the judgment passed by the Kerala High Court in S. Somnathan Pillai and others. Reported in this have been reckoned others was the state of Arunachal, reported in 22-1 GLP 474 and in and the judgment passed by the Kerala High Court in S. Somnath Pillai and others was the state of Kerala and others reported in 2023 3 KLT 187. We are of the opinion that the matter requires consideration, hence admit no need to issue notice to the respondent as the same is represented through counsel. List this matter for. In the meantime, till the pendency of this writ appeal, the interim order passed by the learned single judge. The effect and operation of the interim order passed by the learned single judge shall remain stayed. List for hearing in the month of January 2020.
Well, there was a caveat, caveat may be decided.
It may be discharged.
January first week, Manoj?
Even if it comes in second week or how.
No, this
Still
matter,
the- Still the calendar is in the process. So let us see.
Item 10.
Please, your lordship. Well, this matter pertains to an advertisement by the Indian Oil Corporation for
Where was my number?
give it on item.
Oh, my God, yes, we can do that. Yes, and it's a concession.
Notice.
Well, this matter,
Returnable on so and so, registered AD and Rasti. In the meantime, effect and operation of the order dated 19/4/2024 passed by the learned single judge and rectification number 1206/22 shall remain stayed.
hello.
Item 11.
No, you are all in the person. You were disposal and.
Yes,
May pleases your lordships. Lordships, in this matter, lordship, the petitioners herein have challenged the order of the learned tribunal whereby the transfer order was stayed, lordship. Now, on last occasion, lordships were pleased to pass an interim order in view of the order of the apex court whereby
they
the.
already joined there.
Yes, my lord.
They have joined.
Yes,
Salaries and all.
salary, my lord, paid. Yes,
Oh, be happy there.
sorry.
Be happy at the Calcutta.
Lordship, Calcutta's order has been made absolute. That's why the apex court order has been made absolute.
Lord. The matter is remanded back to the High Court for a decision
At the same time.
by making the interim order absolute. Perhaps there were other grounds in the writ petition.
What happened in Calcutta High Court?
Lordship, I have checked, there is no order as such.
It's a 22/10.
22nd of October, this order has been passed.
27th of October is the next
Okay.
day.
Yes, Lordship.
20.
27th.
Lordship, the next, the matter.
Calcutta.
Calcutta High Court.
No, Lordship, the matter has not come up before the Calcutta High Court yet.
Really? Having heard the learned concept of the party, we deem it appropriate. We are of the view that a matter requires consideration, hence admit no need to issue notices. Parties are represented through their concept. Full stop. The interim order passed by this court. Wide order dated 20th of August 2024 is made absolute. Till pendency of this writ appeal, this writ appeal in the month of January 2020.
Honestly.
Highly appreciated.
Item 12.
once we are. Would you please tell? इनका भी फीलिंग की हमें डॉक्यूमेंट मिली ओरिजिनल काम करेगा जब तुमने पहले वो ऑलरेडी देना है आंसर वो जो 5 लाख का बात करते थे वो एडमिट है एंड सेकंडली वो इट क्लियर ऑन कि इसके यूजिंग हमें ये भी कंप्लेंट की और दैट इज नॉट आफ्टर दिस check
Yes,
May I please, Your Lordship? The petitioner prefers this writ petition against the order dated 30th May 2024, passed by learned Ket Guwahati. Order of dismissal, Your Lordship. May I read the brief facts of the cases? Sir, the petitioner was appointed in the Department of Survey of India in the year 1991. Later in the year of 1995, he was appointed on regular basis.
ma'am, the allegation against you that you issued fake appointment letters and provided the photocopy to that person in lieu of rupees 5 lakhs. You have compromised the matter, paid the money. That is your admission there. What remains then?
Your Lordship, the case was, PRC case was going on in Cesium Kamur Metro. But the case was, he was acquitted in that case, Your
Whatever
Lordship.
it may be, acquittal doesn't mean acquittal on the basis of compromise,
Yes, there
not
was
after a
compromise.
trial. Then you gave him a fake appointment letter. The other select list, you have prepared a fake select list and provided only the photocopies of it. Now your only plea is that originals were not produced. When there was no such originals, in fact, you have provided the photocopies to him. What's the fault with the finding of the disciplinary authority? The circumstances leads only to the conclusion that you have committed that.
But Your Lordship, the
it was not disputed that paid 8 lakhs disputed.
And you have returned the money 8 lakhs by issuing checks also. What was the transaction between you and the person or the victim? So you have paid him by check, the money. Those checks were provided in lieu of the compromise.
Yes.
So what remains?
Lordship. Your Lordship, the petitioner was Your Lordship, the petitioner was asked money to lend by that Ali Zahan Laskar. And the petitioner issued check, but later he blocked his bank account, Your Lordship. To stop payment.
So
He was forcefully asked money by the person who lost the FIR.
then what happened? What steps you have taken against that action or forceful action?
The petitioner informed the police. Later, he filed a complaint case before the Cesium Kamur Metro.
What happened in that case?
Later, the case was got dismissed. The petitioner,
And what remains, madam?
no, Your Lordship, the case was got dismissed for default.
Default means you are not trusted. Against which dismissal, default dismissal, what remedy you have availed?
Did not do anything.
You have not availed any remedy. Then what remains? Yes.
Your Lordship, notice will be issued.
Notice for what, ma'am? At least we should be satisfied that it's a case of issuance of notices. We are listing on it on Wednesday next. Prepare and then come.
Okay.
Still, and counsel to the commissioner says some time to prepare there's some more time to prepare the matter list on Wednesday.
15,
Okay.
29, 30, 29.
Okay, we'll list on 6th of November.
Madam,
Where is ma'am? We are listing it on 6th of November.
6th of November.
Yeah,
Highly obliged.
6th of November.
Item 14,
I am bigger. Not very old. I am practice.
Lordship, it is my appeal against our state order. Lordship, the issue in this matter was,
Delay
Lordship, the delay by,
filing the return.
no, Lordship, the issue was, Lordship, 20/2007. There were two conditions. One was for application for availing the benefit under that notification, and one was for fixation of special rate. Now, Lordship, my application, whether I am eligible for that notification or not, that was itself decided by the department after a delay, which the commissioner acknowledges that on 14/5/2010, I was given a letter that yes, I am eligible for the benefit of this notification. So, Lordship, prior to that letter, there was no occasion for me to apply for special rate fixation. Therefore, within 1 week of that, I filed the special rate fixation, and the commissioner goes to decide against me as well as the tribunal, stating that it is time barred as per the terms of the notification. But Lordship, our honorable court also in couple of judgments after VVF has held that this condition of application is a procedural condition. If the substantial benefit of the notification is not being denied, then this delay can be condoned. That was, of course, in relation to VVF, Lordship, wherein the Supreme Court had held that these all matters were pending for quite some time. Therefore, after that judgment, whatever the applications are there will not be considered as time barred. My case, Lordship, I would like to say it's on a better footing, because on 14/5/2010, department gives me a letter acknowledging that yes, you are eligible for this.
Let's see, page 89 of the appeal, paragraph 7.
Paragraph 7.
Lordship,
Yeah,
heard both the side peruse the appeal paper and other documentary evidence placed before us, we find that there is no dispute about applicant's eligibility for the concession contained under notification 20/2007 dated so and so. It is on record that the applicant have commenced their production with effect from 4th February 2009, and they have started paying excess duty from PLA account from 2009 onward. It is also on record that the appellant were regularly filing their refund claim without waiting for any confirmation from range officer as to whether they are eligible for concession given under the notification or not. They have been filed their application for
but
refund.
their application, what they are saying, their application was decided after this 60 days limitation or whatever it may be. Then
No, Lordship, here,
before that, he was not supposed to file any
no,
application
Lordship,
for
they
this.
were availing exemption since 2009. And Lordship, may please to see paragraph 8. Paragraph 8, page 90. Then the relevant paragraph of the notification has been quoted by that CSET. Paragraph 8, I am reading, Lordship, page 90. A careful reading, the above condition of the notification would clarify that the appellant is required to make their application for refixation of rate that is by 30th of September. After this, the commissioner had discretion to condone the delay for 30 days. This means that the application for refixation should be filed latest by 30th October. In the present case, the appellant has filed application on 24th of May 2010. This shows that the appellant has delayed filing the appeal almost about 9 months. Lordship has seen paragraph 7. They were made eligible in 2009 itself.
20. The delegation.
May kindly take page 62.
See.
So when this eligibility certificate was issued to you,
Lordship, page 62.
62.
Page 62 and actually, that is the letter that the department, 62 Lordships.
14.
My Lordships is there.
14/5/2010.
Lordships. So all my applications is 2009. Lordship, the notification provided, I have to apply. I applied, but whether I am eligible or not, that they will decide. They decided on 14/5/10. So my second step of fixation of special rate, Lordship, special rate was the notification that had defined a percentage, 36%. But if my value addition was more than 115%, I can apply for special rate. So no occasion arose for me to apply for that because I didn't had a letter that I am eligible for this exemption. And as soon as I got it, I applied with it on 24th of my Lordships.
Yes. We'll admit this appeal. We'll admit this appeal and having heard the concept of the parties, we are of the view that the following substantial questions of law arises for consideration of this court. This page number 23, number 1, and page number 24, number 3. Okay. And Mr. Kayal accept notice on behalf of the respondents. Service is therefore complete.
So.
Just in due course. Yes.
Lordship, paying for a smart date, it's 2009 refund. I am waiting.
Maybe so since you are waiting for 2009 defend up to.
No, Lordship, the
2020,
tribunal, that
wait for another 2-3 months.
plain just request, grateful.
Item 15.
Follow.
You move an application for modification or whatever it may be, vacation. How is this writ is maintainable, sir? 226, we have already exercised power. We are exercising power in 226 in that PIL. And again, you have moved this application, you are seeking review by the same power, sir.
My lord, can
If
I
you
just?
move an
My
application
lord,
for
we
modification.
thought
or
over
whatever
the
it may be.
issue. My lord, we initially our view was, why not we file an application seeking implement? Then an order vacating
What's
the,
wrong in that?
for vacation or modification of their order.
whatever it may be.
My lord, of course, that is an option, my lord. What
Is there, sir?
the
What
problem? No, I don't.
we are of the view that
Regarding
is the only option.
regarding the, not only the forum, my lord, even the issue is so delicate. My lord, I was only thinking, subject to your lordship's kind consideration. My lord, lordship would recollect, when the Bombay Betting and that Gambling Act was enacted, the matter went to Supreme Court. The Constitution bench of the Supreme Court had the occasion to deal with the matter. That the contention before the Constitution bench was, my lord, this ban or that restriction which was put by the Bombay Act, it amounts to, a restriction within the meaning of Article 19(1)(g) and Article 301. I'm just coming, my lord. The Honorable Supreme Court, my lord, the Constitution bench said that no, because this is an activity, it is res extra commercial. One who indulges in such activities doesn't have a fundamental right, but nevertheless, he is entitled to some legal right. But then Honorable Supreme Court, my lord, said that these are all regulatory provisions. These are not prohibition. Now, if your lordship kindly looks at our Central Act, 1998 Act, that is also a regulatory, not prohibitory.
Sir, first of all,
It is in that context I was thinking, my lord.
come with the plea that
Yes.
you are a charitable institution
Yes,
and not in that, then
only once in a year.
once in a year,
Yes.
then how this Article 301 or Section 19 will come
No,
in
no, what
play,
I'm
sir?
saying, no, my lord, what I'm saying is, I'm not saying in this case,
301
how the
relation
law
to
developed,
trade and commerce,
no, my lord, we are not doing for any profit.
we are not doing any trade
Exactly.
or any.
No, my lord,
commercial
when I referred to the Honorable Supreme Court judgment, my idea was to apprise your lordships, my lord, how the law developed.
That's right.
Yes, that is, the Honorable Supreme Court said, my lord, that it is not prohibitory, it is regulatory. Therefore, as far as state of Assam is concerned, my lord, there is no such law covering the field. Therefore, the order which we were, looking forward was, my lord, that let state government will apply, state government take a call under 162, they can always, without being influenced by lordship's order in the,
We have simply said in the order, sir,
yes,
that check the illegal operation of the offline and online.
precisely.
If it is not illegal, certainly nobody is.
No, only that much, my lord. If lordship clarifies that, we can
This is-
definitely come in that form, my lord.
This is what we have already clarified, sir.
Yes, that is there, my lord.
The state government shall issue direction.
Page
to all the
63,
district,
yes,
including
yes.
the superintendent of all the district not to grant
Yes.
any permission to any individual organization or offline notaries.
Uh.
In any case,
Hmm.
any such offline, online is found to be organized illegally.
Yes,
The concerned superintendent of police shall take immediate action against those persons organized in accordance with law.
yes. No, my lord, my lord, this order has an element of, my lord, all pervasiveness. That's why the authority will not act, my lord.
Secondly, have you applied before that, sir?
No, my lord,
They have
unless
rejected-
there is some clarification from your lordship.
You just, it is, we are of the view that it is more than clear.
Yes,
And if they refuse to do so,
yes.
certainly you can come and approach us that.
And on last occasion, my lord, on last occasion, they permitted arrest, page 39, 41.
We understand,
Uh.
but ultimately, if you apply before them and if they refuse it, then only the cause of action would arise.
My lord,
Suppose if they come and they
my
say
lord, can I-
it's not an
My
illegal.
lord, can I pray for an observation that it will be open to us to approach the authority and the authority will consider. If that observation is made for the present, it will do.
The definition is, what are the facts and what are the main investigations. From any organization, yeah, when you do find out the state, then maybe they will-
My lord, your lordship has not used the word illegal, my lord. That's why, if your lordship would kindly see, in case any such offline or online lottery are found to be organized illegally. Of course, it is there. My lord, lordship will kindly make an observation, will apply to the authority.
We,
And my lord, there are other litigations are also there. There will come with that form, my lord.
that we will consider. Okay. This petition is filed by the petitioners. Under Article 26 of the Constitution of India. Essentially with the prayer. to modify the order dated 3/10/2024 passed in PAL number 29/2024, whereby this court has issued direction to the state authorities to take action against any offline or online lotteries found to be organized illegally in the state of Assam. Full stop. I'm of the view that for the purpose of modification or vacation of any interim order passed by this court while exercising writ jurisdiction, the proper course is to move an application for modification of vacation or vacation by the aggrieved party. Full stop. At this stage, the net counsel, Mr. K. Chaudhary submits that he may be allowed to withdraw this writ petition. However, seeks liberty for the petitioners to approach the state government with a prayer to allow them to organize lottery.
It's a lucky coupon draw actually to say lottery.
Organize lottery/lucky coupon draw. What is this lucky coupon law? on
Yeah,
the
in fact,
eve
my
of-
lord, copy to vote.
On the,
In fact, it is fixed.
at the time of organization of Holi Ras Mahotsav
Yes.
in state of Assam or Guwahati?
No, it is in Howli, my lord, Borpeta district. It's a,
In
We-
Holi.
we call কেৱল সদস্য আৰু শুভকাংক্ষীৰ বাবে, members and well wishers. They're doing very good work, my lord.
Holi Ras Mahotsav.
Ah.
Full stop. Full stop. In view of the above, this writ petition is dismissed as withdrawn. However, the petitioners are at liberty to approach to move appropriate representation with the state government seeking permission to organize lottery/draw,
Lucky coupon draw. my lord.
lucky coupon draw
Mm.
on the eve of Holi Ras Mahotsav.
Ah.
If any such application is moved by the petitioners, it is expected that the state shall consider and decide the same expeditiously, taking into consideration the provisions of the Lottery Regulation Act 19, lottery in bracket, the lotteries in bracket Regulation Act 1998.
My lord, that will not apply because, my lord, because that is only regarding state organized lottery. That's what I'm saying, my lord.
So no other,
There is no law actually, my lord.
no other organization.
Ah.
This is what the
No, I'm
intention of the
holding the
petitioner.
act, my lord. If your lordship would kindly
Yes.
come to the act, subject to correction, my lord.
Yes,
Yes. Now, if your lordship would kindly come to the act, a lottery is defined and kindly see, my lord, section 4.
Lottery is defined means a scheme
Huh,
in whatever form
huh.
or by whatever name called for distribution of prizes by lot or chances of those persons participating in chances of prize purchasing tickets.
Yeah. No, my lord,
This,
here, my lord, the act envisages a lottery which is organized by the state. Other than that, it is not.
It says, sir, save as otherwise provided section 4, no state government shall organize, conduct or promote any lottery.
Yes.
Promote means promote by any other person, sir.
My lord, this is a debatable issue, my lord.
That's why-
Or this act or any other authority, my lord.
This one. This regulation.
Prima facie, my lord. Can go, we can apply no process.
Endowment में होगी, करना पड़ेगा सर, common person.
Sir, this we are aware of the.
My lord, all that I was trying to submit for your lordship's kind consideration is, my lord,
state has the power to regulate any activity. I'm on that.
Sir, if,
That way-
if that law provides, certainly they'll regulate. and
Exactly,
one time-
exactly.
One time
And
measure they can.
because there is no specific law which governs this
So let-
subject.
Let.
Okay.
apply this thing
Ah.
and they'll
Only thing is,
consider
my
it.
lord, not limited to this act. Lordship may say or any other provisions governing the field.
That go open, I won't be open for that, sir.
And my lord, the-
19 and the regulations. Yes. Lottery regulation rules 2010.
yes.
And the lottery
98.
98 and the lottery regulation act is 2000.
Lottery regulation.
Yes.
We are 106.
Yes, next.
Deeply.
Item 16.
May please the lordship.
Yes.
Lordship, this public interest litigation has been filed by the alumni of Tejpur Academy Senior Secondary School. Your
The
lordship.
parking
Parking.
space.
Yes, your lordship.
This is not done by the education department, my lord. This is not done by the education department. This
That-
is between the municipal board and my lord, the school principal who have perhaps come to an understanding is what I was given to understand. It's a municipal
You are appearing for the
CEO who has
municipal
based
board.
on answer.
That land is, might not taken for temporary purpose only. That one letter, the
Temporary
chairman
purpose
of the
now,
municipal board,
That purpose is over.
that my lord, another plot is one of original plot that construction was going on. That is why temporarily he requested, chairman requested the
For
principal.
how much time?
Of that time, of course, not given.
Not even that, what do you mean by temporarily? Temporarily means 1 month, 2 months, 6 months, what is that? During the vacations, we can understand, you can use that for that any other purpose when the school is not functioning.
Not that. Then lordship may take up the matter for a week.
Your
In
lordship,
the meantime, how much time?
your lordship, your lordship, actually a construction of a market complex is going on. It will take around 5 to 6 years, your lordship.
No,
So
no, no,
that
no,
is,
this-
that is another thing. And in the meantime, the Tejpur Municipal Board has arranged for a parking place in front of Hamburg's Smriti Hodon parking premises. So they have already arranged, your lordship.
So you mean to say that now there is not, they are not in need of.
No,
this
your lordship,
land for that?
just because there is an interim order, your lordship, they have shifted to that place, your lordship.
File your reply.
My-
For municipal, you are for the municipal corporation?
No, my lord, I am actually paying for the deputy commissioner, district commissioner. District commissioner, municipal, nobody.
The
applying for-
government, this school is private or the?
No, your lordship.
Provincialized.
Provincialized school.
Provincialized.
It is not done with. My instructions are no permission taken, no communication made with the department principal.
But if it's a provincial school, how the state can shoot off the responsibility that we are not aware, it's between the.
Our stand is that this school playground should not be used by the municipal board.
Where is
for-
that? Then instruct the authorities concerned or to the municipal board, write it to the municipal board that why you are doing this. Where is that?
Since initially.
You are keeping that it's between the municipal board and the school principal. How can it be? It's government school and the principal without your seeking the consent of giving the property or the parking space for the purpose of using.
Sure, I will after we will bring my instructions on record and then I will take from the guy.
You are appearing for?
I'm appearing for my lord. Chief Secretary, my lord, one.
The same question is before you.
I'm appearing for respondent 145.
Who is appearing for this chairman,
Chairman,
executive
nobody.
officer and principal?
None of it.
Executive officer.
7, 8 and 9.
8 I'm appearing, my lord. This is executive officer.
So, if you are appearing for the executive officer municipal board, you are certainly appearing for the chairman also.
I will take instruction from executive officer. only.
What about this Tejpur Academy school principal?
I'll get the from the diet.
You accept the notice on behalf of. Nikki. Mr. R. Majumdar is appearing on behalf of the respondent number. 1, 2.
Is appearing for 2, 6,
2, 3, 6 and 9.
2, 3, 6 and 9. Mr. Tunso is appearing on behalf of the respondent number 1,
4, 5,
4,
5 and 8.
5 and 8, 5, 7 and 8. 5, 7 and 8. Full stop. They may file counter to the writ petition if desired so by the next date of hearing. In the meantime, the interim order passed by this court on 20th of December 2023 shall remain in currency till next date. List of proposals.
Item 17 to 19.
Yeah. It will require some more time, well, the consultations are going on and there has been a recent judgment by a coordinate bench.
So that judgment doesn't cover.
But it doesn't-
covered, squarely covered.
What happens
Covers
is
that tutor and all.
what happens is this, my lord. In that particular judgment, it has been held that teachers and tutors are both performing the same duties. We are consulting with the department on that, my lord. There are some reservations on that. Otherwise, my lord, what has happened is they have asked for a raise in the pay. What is being given to them. And the judgment of the other court, my lord, does not actually deal with the pay which is supposed to be given.
But once the court has decided that the duties of the tutors and teachers are the similar.
That is what, my lord, we
Examine that and whatever the relief we are there.
So already they have taken decision, page 51.
51.
Yes, Lordship. Lordship may kindly have the retreat, the item number 19. 2729, page 51.
19 to
Because under section 83 and 84.
19. Item number 19.
Lordship may kindly have the repetition number 19 1637 Abdul Majid Ahmed, where I have annexed that particular decision of the government whereby the work schedule and condition of services they have prescribed, page 51. Because this was done in view of the section 83 and 84, which is put to challenge here. Let's see, kindly see.
51. Yes.
Annexure 2 page, that's from page 51.
Yeah.
May I read, Lordship?
Yeah.
In exercise of powers conferred under subsection 3 and 4 of section 8 of Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017, the Governor of Assam is hereby pleased to notify the following scope of works, terms and conditions of service in respect of tutors whose services have been provincialized under this act, namely. Now, Lordship, relevant is clause 2. The tutor shall continue to perform the duties as per the earlier responsibilities prior to provincialization. Now, illustration given, if the service of a science graduate teacher is provincialized as tutor, she shall have to teach science subject as was done earlier in the school prior to provincialization of his or her service. So the learned coordinate bench held that since they have discharging the same duties and responsibilities of a teacher, they are also entitled for a scale. That is why direction is given by order dated 4th of October that the authorities should come up with a rule within a period of 6 months and pay the minimum pay scale. Then, Lordship, paragraph 3, a tutor shall be assigned duties, same duty. So here, Lordship, our grievance is that although we have I'm having the judgment from there.
The judgment,
Judgment.
Yes,
copy.
Lordship, the preliminary lordship, I'm having only one copy, sorry. Lordship.
page relevant.
Lordship,
Para 160.
it starts from. Let me look at it.
160.
Page 666.
Para 1.
Page 166, Lordship, paragraph. But I have already flagged back there. First one is the issue at page Lordship will find at page number 590. That was the issue. And thereafter the issue decided that Lordship will find at page 666, paragraph 162.
590.
590, that was the issue under section 83. And then it was
8.3 of the T, the petition of submitting various segment of formal note, approach this for telling section of the ground, the same and with all consequential benefit will take from the the various.
now Lordship come to 666.
Yeah.
162, may I read Lordship? The next question that arises for consideration in this batch of writ petition is pertaining to the remuneration of fixed salary paid to the tutors upon provincialization of their services. It will be pertinent to note herein that under the Act of 2011, the category of teachers known as tutor was not included. The expression tutor, however, appears in the Act of 2017, which refers to that category of teachers in venture educational institutions who did not fulfill the qualification norms for being appointed as a teacher under the section 23 of the Act of 2009. However, in view of the long years of service rendered in this category of teachers and with a view to extend the benefit of the Act of 2017 to them, the term tutor was used in the Act of 2017. Now, the various definitions has been discussed. Now, let's kindly to paragraph 166. What was the submission before the Honorable Court? 166 paragraph. According to the Learned Council, appearing of the group of
All these petitioners, they are provincialized.
Yes. We also provincialized. Page 170.
So that paras 175 is lordship.
175.
My lord, it is.
Yeah, 170.
Mary
As noted above, the provincialized teachers and tutors
are similarly situated.
insofar as the status of government employees is concerned. To that extent, they are entitled to be treated alike, whether the quantum fixed of salary paid to the tutors is just, reasonable, or adequate is neither a question raised before this court, nor are we inclined to enter the said aspect of the matter. However, following the equality cause emphasis in so and so, if any pay scale is extended to tutors considered fit and proper by the government, the same would, in our opinion, meet the end of justice. That is what has come in 175. Prayer number 1 in the
180, then come to this, para number
170.
179 and 179.
179.
It is true that courts cannot direct the legislature to enact a law in particular manner. However, in discharge of its statutory obligation of the government in exercise of its rulemaking power will have a duty to frame rules for proper implementation of the provisions of the statute. While framing the rules, the state will also be under a bounden duty not only to act in terms of the scheme of the act, but also to unflinchingly adhere to the constitutional norms of equality. It will therefore be in the fitness of things that the state government itself, on its exercise of its rulemaking power under section 23 of the Act, takes necessary steps to provide for a regular pay scale to the tutors, which can even be commensurate to the pay structure indicated in the schedule of the governing act. Such a measure, in our view, will restore the equality of treatment in this category of teachers with the other government employees, and at the same time, will not be burdensome on the exchequer. We therefore direct the respondents to initiate necessary steps in the observations made here and above as expeditiously as possible, preferably within a period of 6 months from today.
Moderate training, they simply said, the frame a rule for granting regular pay scale or whatever it may do that. Not, even though it can be different from the teachers or whatever it may be.
This judgment having come recently, we have Lordship, have it on the next week, my lord. We have sent the judgment to the department. They are in consultation with, we are also.
So we are not doing anything. In this petition, these petitioners who are tutors and whose services have been provincialized, sought, so and so, this court in division bench so and so has already taken into consideration the similar grievance raised by the tutors and pass the following order. We deem it appropriate that this is squarely covered by this, those disposed of in terms of this. That's all. We are not doing anything else.
I have just have my instructions, my lordship will have it at two, my lord.
Nothing doing, sir. We are for that.
My lordship will
For
have
the
it.
purpose of deciding a controversy, we are not in requirement of any instruction from the state.
Lordship will appreciate we did not have
Once
an
we-
affidavit on
once
record, my
we
lord.
are convinced that it's okay, then it's okay. Why to keep these petitions? pending?
No, I'm not
What
doing for pending, my lord. Lordship, this is about two, my lord. I'll just have a discussion.
And last occasion, my learned friend said that the matter is under active.
I still have my instructions
For-
today morning saying
We
that
are not
they are
giving you any
insufficient.
direction. We are simply disposing of this petition in terms of this judgment. That's all, and nothing else. We are not giving you any direction at all.
We don't dispute. It's automatically
It is
covered.
automatically covered. Yes.
So one more, I have additional lawsuit. So far, the teacher is concerned lawsuit, facilities of health loss insurance is provided to them. But in respect of tutors, no such
Sir,
facilities are
Now,
provided.
what the division bench has held, that the frame the rules, whatever it may be, that
That may indeed,
covered the frame rules regarding all the emoluments, etc.
welfare
salary,
measure, that
etc.
welfare measure may also.
Covered by that.
Yeah, item number three.
These writ petitions. These writ petitions are filed by the petitioners challenging the validity of the provisions of section 8(3) and 8(4) of the rules of 2017, rules of 2017. The petitioners have also prayed for issuing a mandamus directing the respondent authorities to grant minimum pay scale to them or to enhance the fixed salary, fixed monthly salary as per the existing rules and regulations. Certain ancillary reliefs have also been claimed in these petitions. Stop. It is noticed that a coordinate bench of this court, while examining the validity of provisions of the Act of 2017, including section 8 and 9,
8(3).
including section 8, has issued certain directions. While deciding so and so is reading of this court in so and so place. Writ petition number, so I am connected.
First to review.
In writ petition number 2729/2019, Mohar Ali Sheikh and 22 the others. What says? State of Assam and others, and another other connected writ petitions. While examining the validity of so and so, has directed the state government to take necessary steps to provide for a regular pay scale to the tutors, which can even be commensurate to pay structure indicated in the schedule of the governing act. Full stop. इसमें शुरू में क्या लिखा था? This writ petition is filed by the शुरू में in start what we have dictated. Petitioners, comma, who were earlier engaged as tutors, but later on their services have been provincialized as tutors, comma. Provincialized as tutors under the provisions of Act of 2017, comma, challenge the validity of so and so, so and so. the operative portion of the decision of the coordinate bench of the decision of the coordinate bench of this court on the issue is reproduced here under this 179, para number 179, page 647, reproduced here under. Having heard the learned counsel of the parties and after going through the material available on record, we are of the view that the issue raised in this petition, in these petitions is squarely covered by the decision of the coordinate bench rendered in so and so, so and so. Hence, all these petitions are being disposed of in terms of the judgment dated so and so passed by the coordinate bench in so and so. All interrogatory applications are also disposed of. If अगर कोई help है. There are any interrogatory applications? No interrogatory.
No,
application?
No eyes.
Don't do it, huh? 17, 18, 19.
Obligation.
Also, while framing, there was only one observation that facilities welfare measure regarding the health. And that may also be taken
The elaborate order, the division bench has passed an elaborate order. As per the this Act of 2017 frame a scheme for regulating the pay and whatever the other amounts, certainly they'll consider. No further, once we have covered this controversy with this judgment, we can't add.
Initially, lots of petitioners were appointed as a teacher, not teacher. Initially, the petitioners were appointed as a teacher, not tutor. Their service are provincialized as a tutor, but initially as teacher.
Initially appointed as inventors, subsequently provincialized as tutors. And then I put it.
Obligation.
Item 20.
I mean, next round, I mean, look for it.
May I? This matter pertains to the family pension to the second widow, my lord, wife, my lord. My lord, we approve the honorable Central Administrative Tribunal, Guwahati, my lord. And as per order dated, my lord. My lord, at page 52, my lord.
रिटायर करने के बाद एक दिया है उसमें वहां पर वाइफ तो गुजर गया था एक दो बच्चों को और इनका दो पिटिशन से वापस बाहर है मतलब इन्होंने नहीं कुछ नहीं करना है तो इन्होंने क्या किया रिप्रेजेंटेटिव वो एक स्पीकिंग ऑर्डर पास किया सर पेज 64 अब उन्होंने दो मेरा ये फैमिली होगा इसको second wife, don't because of the private content would be ended. But the railway guys that now responsibility don't have anything. From the application. This bit of question of age of different rates. Name as a name as extreme fear in the past after that but इनका डॉक्यूमेंट यहाँ पे लगाया है सर पेज नंबर First one is page number 33. Yeah, 11/10/2004. These two things are not reflected in the. No, the application on for opinion. यहाँ पे सर रेस्पॉन्डेंट का कुछ नहीं है। हाँ, लेकिन मैंने वो उनसे पर वो नहीं कुछ नहीं है। वो कुछ
Whether this in OA, the response was filed on behalf of the railways.
Yes, my lord.
They have filed that affidavit.
Yes, affidavit has been filed.
Why not next with this?
My lord, I am not an ex. You will affidavit.
वही देखना पड़ेगा वो इसमें वो रेफर नहीं
Yes, ma'am.
Lordship, we have received parawise comments, 3 weeks time may be granted to file
So
affidavit.
we should have mentioned it at the start. For whom you have waited for this?
Where is the reply? Affidavit.
The concept.
Affidavit is there.
And the white user gave the 20th school. This is 1004. The statement has a wait. The OA is also not annexed. OA.
OA is not an.
Please annex the OA and the response filed by the railways, then only we can ascertain.
My lord, I will file an additional affidavit.
Detail on the concept of the petitioner pays for and granted time to file the original application filed by the petitioner before the CAT as well as the response filed by the railways in the said original application. Full stop. Learned counsel for the respondent is also granted time to file counter to the writ petition. List after 6 weeks.
Item 23.
This matter, state is yet to file their reply. Otherwise, with greatest respect, madam, the judgment itself speaks for itself, madam. If your lordships are.
But they have also not commented in the, they say they are only with the. The whole proceeding have been live. Retirement is everything. Just 19 the proceeding is right now. He cannot be considered. Mr. Chaudhary, there was a departmental proceeding against you.
Yes.
Rightly, wrongly, 2019.
Mal.
That was under stay.
Mal.
So, but the departmental proceeding remained. So, from your pleadings, we see that your earliest promotion could have been somewhere in 2019 because he was promoted, that was interfered with. Now, in view of that departmental proceeding pending, how can your case be considered?
2019 proceeding came to an end, man.
Departmental proceeding. There was a stay.
There was a stay. I'm not on that one. If your lordship,
we are on that.
I'll come to that. But if your lordship kindly comes to the judgment at 411.
Yeah.
What was taken note of was something completely different. If your lordship comes to page 216 first, 416 first.
Para.
416.
Para.
There's just before that.
Para.
Before that, I wanted to place the dates. Your lordship will kindly have a look at the date of the hearing and the date of judgment. Now, your lordship will have a look at the findings.
Sir, that's why only we entered into the merit. And brother has asked you a question. Since the disciplinary proceedings were initiated against you, those disciplinary proceedings were stayed by this court. During the pendency of those disciplinary proceedings, certainly you are not entitled for promotion. And that writ petition came to be dismissed as infectious.
Mal.
You got it dismissed as infectious.
But that is the problem. Your lordship will kindly see. On the date on which the hearing took place, everything was alive.
No.
Now, what happens is, if your lordship kindly comes to para 16.
Yes.
Page 419. These are the findings that emerged from the records. In fact, para 15 onwards, if I may please. During the deliberation of the matter, pursuant to the order of the court, the official respondents of the Food and Civil Supplies and Consumer Affairs Department and the APSC placed all the relevant records pertaining to the Departmental Promotion Committee's decisions dated so-and-so and so-and-so regarding promotion of the private respondent so-and-so to the post of Controller of Legal Metrology and consideration as well as approval of the APSC in that regard. Next para. On perusal of the records, it was found that though the private respondent number 3, so-and-so, as Principal Secretary so-and-so, was not the member of the selection board as constituted by the Chief Secretary of the State for selection to the post of Controller of Legal Metrology, but he managed to participate in the concerned DPCs for this said promotional post. Moreover, the record also reveals that the said private respondent number 3 prepared the minutes of the concerned DPC promoting the respondent so-and-so to the post of Controller of Legal Metrology much ahead of the said selection committee meeting held on 26/11/2019. Said respondent number 3 not only prepared the minutes promoting the respondent so-and-so, specifically stating that the agenda note for the selection board meeting to be held on so-and-so at 2:30 p.m. signing the same as on 26/11/2019 by him. It is also seen that the agenda note was forwarded to the Chief Secretary of the State on 22/10
2019, fixing the meeting on 4/11/2019 at so and so, that was approved by the Chief Secretary on 22/10/2019 itself, which was subsequently postponed to 26/11. So even before the meeting, DPC could meet, everything was done. And
But what learned brother has asked, that during the pendency of the disciplinary proceedings, you are not supposed to promote it.
but all these things would have been considered by the DPC. I am on that. They would, rightly or wrongly, I am fully conscious of the fact that promotion is not a fundamental right, but a right to fair consideration is certainly which has been time and again held by the apex court to be a fundamental. That is the consideration I'm. WBC 211 to here. Stay episode here.
This petition that which something has been confined to WPC 9459/2019, wherein talent was to be minus plus written. I think go other landing. Oh, revise what you have. 19 से revise what you have. We can't even connect it. Because he's written, that is one thing. Consideration would be a stupidity. So we cannot be promoted.
And the departmental proceedings that my Lord Justice Krishnan is talking about is what that writ petition did not receive any consideration at all.
There was a
stay, but ultimately this got dismissed as infractions along with this.
And which
So you are not challenged that order.
I am challenging the judgment as a whole one.
No judgment as a order. You are challenging only this 9459. You are not challenging this 9019 9109 as well as
211.
Your praise is specific to this in the appeal itself.
I am instructed that we have craved leave to appeal, but that perhaps has not been filed.
Page 28. Towards the end of that para. Towards the end
The
of
instant writability is confined to writ petition number whereby the challenge of the minutes of the meeting withdrawing so and so earlier notification so and so. That's all. You have confined your challenge only up to this. You have not challenged that dismissal of the writ petition as infectious wherein the disciplinary proceedings were under challenge. Then automatically after dismissal of that writ petition, the disciplinary proceedings revive.
Because the interim orders were also vacated, sir.
There also, let me take instructions on that, my lord, but I am instructed that they have craved leave.
Unfortunately, legally,
that will have a hearing.
Yeah. After a week. Your insist.
Challenge for the
Item 24.
Yes, please, your lordship. Kindly matter will be taken on Wednesday or Tuesday, my lord, because well, I have listed some relevant apex or judgment of the apex court, man, which I am going to rely, my lord. Kindly on Monday, Tuesday, or any day, my lord. He has already been taken back in service, my lord.
Two people were involved in one, the court has already set
Well,
aside.
he has already been taken back in service, my lord.
Hmm?
He has already been taken back in service, my
So
lord.
then,
That, my lord, the seniority and that back wages, I am on that, my lord. 2 lakhs, sir.
common to both,
Yes, ma'am.
what remains, madam?
On Monday, on that day, fourth May, Tuesday, my lord. It's not satisfying. Me, too.
8th of November.
Most of it.
25. May lordship, please. The last occasion, you may remember that
Yes.
query raised here. That we have examined, my lord. Our humble submission is that the application, that writ petition which entertained by the courts, by the single judge, it is under Article 226.
Oh,
And there is some judgment and our high court, some two notification I have placed before this honorable court. So it's amplifiedly clear, my lord, that so for the Industrial Dispute Act is concerned, it is to be the all petition under 226.
no.
Lordship, kindly have a look. In the roster also, my lord. In fact, as per roster, it's under the bench 4 matter.
Ultimately, we have to see, sir.
And there's 4 judgment I have placed. My lord. With the indulgence of this honorable court, I will place, my lord. Petition. Before that, my lord, I would like to request this honorable court just to look at my application, my writ petition and my prayer, my lord. The Supreme Court says.
Relevant.
No,
We
the
have to see the learned single judge exercise jurisdiction
under
under 226 or 227.
absolutely correct, my lord.
So whatever the industrial tribunal is having all the elements of the civil code. And once it has, because
It's a quasi judicial, it's not judicial court.
it's not a judicial court, but having the this elements of the civil code, sir.
What-
Taking evidence, filing claims, written statements.
One judgment
taking
of Honorable
evidence,
Supreme Court, my
everything.
lord.
Yes.
One judgment of the Honorable Supreme Court, question was raised, whether intercourt appeal, letter patent appeal is maintainable or not against an error. Now, High Court says that the intercourt appeal is not maintainable. That's went to the Supreme Court says, no, it's under 226, so intercourt appeal is maintainable. May I place that judgment? Before that, my lord, I am just requesting this honorable court just to have a prayer of my writ application.
So writ application.
I am
just-
praying for a writ of certiorari. Now, the Supreme Court says that while deciding the maintainability issue of the intercourt appeal, the honorable court has to examine the nature of appeal, the nature of petition, the prayer, and also the jurisdiction exercised by the single judge. Now, my prayer is, as per my petition,
So
I am
your
praying for
prayer or nomenclature of the writ petition board.
that also Supreme Court says.
They have
But
specifically said.
I'm just
Immediately,
invited
what
the
power
first
the
judgment.
Single judge or writ court has exercised, we have to see that, sir.
My first request to this honorable court is, Lordship will kindly have a look of my compilation
Yes.
that by an order of this honorable court dated 92, the civil rules for this part is concerned is divided by bench A and B. And the Industrial Dispute Act that is covers by the bench B. And all these bench A and B all are regular.
The act itself provides for that. Court can have dependent of over all courts and tribunals towards the territory in relation to the activity. And so enforcement. The armed forces will not have, and this is rules of training.
Mr. Pant, you have to examine this matter.
Lordship, I want just before that, just place the judgment of the Honorable Supreme Court, if your Lordship allow me. Let's say, in my compilation, at page, Lordship will find at page 19,
19.
19, my Lord. A relevant paragraph is at page 23, my Lord.
Fine.
Paragraph 11. He say, a matter is relates to, is an application, read petition filed under Article 227, challenging an award of the labor court. The division bench says that the intercourt appeal is not maintainable. Went to Supreme Court. Para 11, kindly have a look.
Yes.
Page 20.
Yeah.
May I read, madam?
Read.
In such and such. Now, even when the cause title of an application, both Article 226 and Article 227 of the Constitution have been mentioned, the learned single judge is at liberty to decide, according to the facts of each particular case, whether the said application ought to be dealt with only under Article 226 of the Constitution. For determining the question of maintainability on appeal against such a judgment of the single judge, the division bench has to find out whether in substance the judgment has been passed by the single judge in exercise of the jurisdiction under Article 226 of the Constitution. In the event in passing his judgment on an application which I had mentioned in its cause title, both Article 226 and 227, the single judge has in fact invoked only his supervisory powers under Article 227. The appeal under Clause 15 would not lie. Clause 15 of the latest patent expressly bars appeal against order of single judges passed under revisional supervisory power. I just keep the lines, my lord. The second paragraph. Thus, the determining factor is the real nature of principal order passed by the single judge, which is appealed against, and neither the mentioning in the cause title of the application of both the articles, nor the granting of the ancillary orders thereupon made by the learned single judge would be relevant. Thus, in each case, the division bench may consider the substance of the judgment under appeal to ascertain whether the single judge has mainly on principally exercised in the matter in jurisdiction under 226 or under Article 227. In the event in his judgment, thus I am pressing upon, the learned single judge himself had mentioned the particular article of the Constitution, as in the instant case, my lord, under which he has passing his judgment. In an appeal under Clause 15 against such a judgment, it may not be necessary for the appellate bench to elaborate examine the question of its maintainability. When without mentioning the particular article, the learned single judge decide on merit the application in order to decide the question of maintainability of an appeal. Against such a judgment, the division bench might examine the relief granted by the learned single judge. When more than one relief are granted by the learned judge, single judge, the maintainability of appeal, the determination would be the main and not the ancillary relief. When a combined application under 226 and 227 of the Constitution is summarily dismissed without reason such and such. Now, in this case, another case has been dismissed.
No, we understand that. We
Now,
are aware of that.
Article 4.
We are aware of that. Now come to this. Guwahati High Court Superintendents of Tribunals Rules 1992.
Yeah.
Have you gone through that?
No.
In exercise of powers conferred under Clause 1 of Article 227 of the Constitution of India, the Guwahati High Court makes the following rules. where the superintendent's powers have been
That's,
defined
that's the,
on the labor code, industrial tribunals, MACT, state transport appellate tribunals, etc., etc. So once the learned single judge has exercised this supervisory jurisdiction under Article 227, certainly it would not lie.
the learned single judge exercise his power under 226.
So how can he be, when he was, the High Court can only exercise power under Article 227? How can we deem it, sir? Just go through it. Once the supervisory powers, the rules have been framed under those supervisory powers. How the learned single judge can exercise the jurisdiction under Article 226?
Okay,
Apart from
against an award of the labor code, my lord.
Apart from that, sir, the labor code or the tribunals, industrial tribunals have all the tenets of civil law.
IDA, industrial disputes.
The claims are to be filed, written statements are to be filed, then issues are to be framed, evidence is to be taken. Everything, these are the tenets
So
of
there's
civil law.
some portion, though not all.
Sir, I say,
The evidence is not applicable, my
tenets
lord.
of civil code doesn't mean that exactly the civil code.
The only the four criteria that has been followed on summoning and discovery and inspection.
Issues, framing of issues.
No, not required, my lord.
Why?
Not required, because the labor code has to decide the reference only. The labor code absolutely is not a civil code, my lord. And my respectful submission is not a civil code. It's a quasi judicial tribunal.
Article 227 courts and
Courts and tribunals.
Because all the award, my lord, all award challenging before the High Court, before this particular our High Court, all 226.
Again, the question comes, when the rules, the High Court rules specifically says that the court is exercising jurisdiction, the supervisory powers on the labor courts and all, and the rules have been framed while referring to Article 227, whether it can be presumed that the learned single judge, despite that, is exercising powers under Article 226.
Every labor court will be deemed to be a criminal civil court. Section 11
Of the Industrial Dispute Act.
and 3, 8 clearly gives a
Section 11 says.
That is there, my lord. But as per roster also of our High Court, is bench so matter, my lord.
Roster, what do you mean by rules are there?
And that is where roster has to be changed, my lord, with all respect. All respect. Roster
If it
has to
is
be
so,
changed. It is a civil bench one.
Even though, sir, if the rule specifically says, that we are exercising supervisory powers under Article 227, how would they, any court can assume jurisdiction under Article 226 for deciding a labor dispute?
Therefore, there is a all and entire thing in our High Court will go into the wrong direction, my lord. With all
What
respect.
wrong direction?
Because
What do you mean by wrong direction, sir?
yes. Why I'm saying, my lord, that we all respect, subject to correction by this honorable court, that it is not a civil judge, civil bench one matter, number one. Number two, always.
How?
And
Simply because the roster says that these matters would be heard by one of the judges, it doesn't mean that they are exercising power under Article 226.
And-
The rule itself says.
And as on today, my lord, as on today, subject to the judgment of this honorable court.
Mr. Papa, this is the rule we have. And you are talking of the roster. The roster is the discretion of the Honorable Chief Justice.
Absolutely correct.
It is only for the purpose of convenience that bench 1, bench 2, bench 3. A matter in bench 3 can also be placed before bench 1, subject to correction. So
Yes,
that
sir,
will not be
absolutely
determining
Correct.
The
I
roster
voted
doesn't
down, my
say
lord.
the exercise of power under Article 226 or 227. We are not specifying. that.
What, Lordship,
How can you claim that?
before this, as on today, all the labor court matter that we file under Article 226 and all
You
is
may,
placed
whatever
before
the
this honorable
nomenclature
court.
may be, whatever the nomenclature may be, we have to see whether the court has exercised power under Article, learned single judge has exercised the power under Article 226 or 227. That is for this court to examine. Whatever the nomenclature may be.
Now, Supreme Court has said when the learned single judge has exercised his power under 226, then the intercourt appeal is maintained.
That's why only then these rules of 1992 come into play. That's why only rules of 1992 come into play.
He has not examined that.
Not example.
You have not examined this rule.
Yes, my lord. Yes, I'm not, I've not gone through.
Please take your time, own time, and then examine and then argue.
Let the matter be adjourned because this is an important question to be decided because it will also take a precedent to all other matters because times to come. Then this is the first time, my lord, with all respect, this is the first time this issue has been raised because as on today,
For the first
Lordship,
time,
yes, yes.
once it is raised,
We
once it
appreciate,
is
my lord.
raised, it has to be decided.
Yes, yes, yeah, I appreciate the entire thing. Now, otherwise, Honorable Justice Nair also is, well, though we have filed all intercourt appeal before that also. Maybe against,
Don't make
against,
any personal remarks, please. Don't make any.
so therefore it needs to be examined, my lord. On 22nd, if it's possible, Lord.
11th of November. When it concerns the petitioner, appeal and place some more time to satisfy this court regarding the maintainability of the.
Lordship may kindly accommodate, and I'm just humble request.
Wait a
Personal,
11th of
difficult.
November, sir.
My personal difficulties.
22nd now.
22nd.
What about 26th November?
Grateful, man.
Writ appeal. 22nd.
20. Grateful, man.
Much better.
Item number 26.
This is appeal by the revenue. Against the order of the CSIT. Lordship on 8/12/2023. Two substantial questions were framed by this honorable court.
We have observed on the last date that this question of law, he has raised the objection that it is only purely a question of fact and no question of
That he
law.
can, that he has liberty law under section 35G. Lordship under section 35G4.
Yeah.
The appeal shall be heard only on question of so formulated, and the respondent shall be shall at the hearing of the appeal be allowed to argue that the case does not involve such question. He has liberty, Lordship.
What he is saying.
Lordship, that is why we had filed the sestet paper book also. Your Lordship had given me leave to bring on those records because Lordship, in both the appeals, Commissioner appeals as well as sestet has decided the entire appeal on facts and stated that there is no disputed question of facts that this is not a new unit. Lordship, it again goes back to 20/2007, wherein my earlier unit was closed. Then and the entire machinery was shifted to Rajkot. Then when the new industrial policy was raised by the government of Assam, then Lordships, we applied for fresh license and we applied for fresh registrations, fresh factory license, fire license, all the licenses were given. So first refund application that I applied in the month for the month of November 2009, Lordship, it was rejected. But in that it was held that I am a new unit. It was rejected on the ground that I have not exhausted my Senvet credit. Because unless I exhaust my Senvet credit, I cannot claim a refund. So my refund got rejected, but I am a new unit as per the industrial policy that was established.
Where is that order?
Lordship, the first order is at page 134. Lordship, in my...
Where your application as a new industrial unit was rejected, registration was.
Lordship, that I am a new unit, it was accepted by my refund was rejected on other ground.
Where is that?
Page 134, Lordships.
134. Yes.
Lordships, may I place this?
Yes.
May I place this? Lordship, the serial number 2 onwards, I'll read. Para 2 onwards. All documents have been forwarded to Superintendent Central Excise, this, for verification report. The range office where his letter dated 12/3/10 submitted his verification report, whereunder he stated inter alia that he visited the factory of the SSC and verified the documents with the original copies forwarded by the SSC and found in order. The range officer also stated that he verified the ground plan with the original copy duly approved by the Chief Inspector of Factories and found in order. He further stated that the unit of the SSC started their first commercial production from 14/10/2009 as recorded in the DSA register, and their first clearance was effected on 9/11/2009. But Central Excise invoice number 001 dated this. The range officer has stated that he conducted the physical check of plants and machineries installed in the factory and found to be in existence. I have also visited the factory and caused verification of the documents submitted by the SSC against their claim for eligibility of exemption from payment of duty and consequential refund in terms of notification 20 by this as amended. On examination of the documents, that is a certificate issued by the Directorate of Industries and Commerce, Dibrugarh, Assam, DSA register, and from Central Excise invoice number 001 dated this, I find that the SSC's unit is a new industrial unit which commenced commercial production after 1st day of April 2007. I have verified and found that the unit has commenced commercial production on 14/10/2009, and they have effected first clearance on 9/11/2009, which are evident from the DSA register and from the Central Excise invoice number this. I therefore find that the unit of SSC is eligible for exemption under clause 8. I stop here, Lordships. So my eligibility was determined through this. Now, Lordships takes the penultimate part of the order at page 138. Yes, page 138 order. I find that Mr. Sardar Plywood this is eligible to avail the exemption under notification dated this, but as the SSC has sufficient sandbed credit available to him on the last day of the month under consideration for payment of duty, therefore the refund section in the month of November is nil. So my refund was stated to be nil, but I was determined to be a new eligible unit. Against this, the department carried this to the first Commissioner Appeals. Commissioner Appeals rejected the departmental appeal. Lordship, that order is at page number 159. It was departmental appeal, Lordship. I had not preferred the appeal there. Yes. Page 159, Lordship. Kindly takes the relevant, Lordship, the discussion and finding will come at page 166. Yes. Para number 6, Lordship, page 166, may I please? Yes. As for the divisional forest officer's letter relied upon by the department in their appeal, notwithstanding the veracity of its content, it is not a sufficient ground to claim that the unit is only a renovated one. Renovation is generally understood to be refurbishing of premises and not the fresh establishment of industry with fresh clearance from all concerned department, including the fresh Central Excise registration after commissioning completely new machinery after a long gap of closing the old unit by all means as discussed in the brief. In these circumstances, it is not apprehensible as to how the department has interpreted that the present unit is the same premise, is the old, the discontinued, and the business reintroduced. Renovation and refurbishing words used by the department in the appeal are misleading, and the appeal is the product of misconception of facts. Irrespective of the above findings on gender eligibility of the notification to the respondent, I do not feel it necessary to interfere with the impinged order. So, Lordship, again, it is the departmental appeal gets rejected because the departmental appeal was only on the ground that I am not a new unit. Now this they carry to the tribunal. Lordship, the tribunal order is at page number. It is on page 35 of their appeal memo. I apologize, Lordship, because I have placed the paper book placed before this estate. Page 35 of their appeal memo, Lordships. Yes, Lordships. Lordship, I'll take you to para number 6, which is at page 37 onwards.
Page 35. Not
37 lots.
Relevant is page 37, para number 6.
So here. Page number 35.
Page 37, para 6 onwards, Lordship.
Just a minute.
Lordships.
Yes.
May I please, Lordship? On perusal of the records placed before us, we find that it is a fact on record that the unit of the respondent was functional prior to 12/12/96, when the ban was imposed on the industry of the appellant. Thereafter, the appellant surrendered their factory license on this and also surrendered their excise registration on this. Moreover, machinery was also transferred to the Rajkot factory and list of the machinery was also produced before us. Some plant and machinery was sold by the appellant. That details thereof was also placed on record. Director Shri this also resigned on this from the board of directors. Thereafter, the appellant has obtained license from the office of the divisional forest officer, Dibrugarh, Assam, while letter dated 6/8, wherein it has been mentioned that in pursuant of the above, a fresh license is being issued to your industry, bearing number dated this. The learned council produced registration and license to work of a factory from government of Assam, dated 16/9/2008, and sanctioning of loan from the Northeastern Development Finance Corporation Limited, while letter of sanction dated this. They have also produced certificate issued by the District Industry and Commercial Center, Dibrugarh, Assam. The certificate of registration with effect from 21/5/9. All these documents have been verified by the Commissioner Appeals in the impugned order and thereafter observed as under. The relevant extract which I have shown you, your lordships, the Commissioner Appeals order is extracted. Para 7. We have gone through the finding of the learned Commissioner Appeal in the impugned order and the documents placed before us, which are evident that the respondent has established a new unit, although at the same site. In these circumstances, we do not find any infirmity in the impugned order. So, Lordship, the whole issue goes back to the visit of my factory by the then learned assistant commissioner and the superintendent, who visited and formed an opinion that I am a new unit. On all both the levels, at the first appellate level as well as the tribunal, on the facts and the documents produced, it has been held that I am a new unit. In fact, Lordship, the Commissioner Appeals gave a class finding that it is a misleading interpretation by the department. There is no dispute in this fact that all the licenses were new. I was eligible for a new unit, and the fact-finding authority has found that yes, I am a new unit. There is no iota of evidence to prove that this is the old unit, Lordships. Under these circumstances, Lordships, and in fact, Lordship, because of this, all my subsequent refund claims are tied up, pending, because my eligibility is still in dispute. So in fact, if I can take you to Lordship, to what?
Just,
Lordship.
is the impugned order passed by this?
Lordship, that was in page 35 of the.
35, na? 35.
Yes, Lordship. It starts at page 35 of the.
वो इन्होंने यहाँ पे बनाया तो जो लीगल कॉपी करते हुए
Well,
Not so,
this question, substantial question number A,
not it.
read.
Regarding whether the CSAT part in law in holding that obtained phrase license by the respondent after Bain was lifted by the Honorable Supreme Court on the basis of the report of the High Power Committee amounts to establishment of new industry and entitlement of benefit of notification of 25/4/2007.
Where is the finding of SESTAT in this order? This, what you have referred to? Where is this finding? SESTAT has had no holding that obtaining of rights by the respondent after ban was lifted by the Honorable Supreme on the basis of the new industry and entitled benefit of notification. Where is that, sir? This
That's it.
finding, where is this finding? The discussion starts,
Page 37, paragraph 6.
paragraph 5.
Paragraph 5 is heard the parties considering the submissions.
I have gone through the record, including the case law, so and so, hearing observed factor state as could be. Now read this. Where is the
In
finding
order
recorded by?
it is evident that the respondent established a new unit, although the same site. In the circumstance, we do not find an ambiguity in the same site. Let's see, paragraph 6, some observation is made.
SESTAT.
Yes.
Paragraph 3.
It's para number 6, page 37.
Not
SESTAT order. Where the SESTAT has held that this
what's,
Obtaining fresh license matter after ban was lifted by the Honorable Supreme Court on the basis of the report of the High Power Court amounts to establishment of, where is this? It has never held this.
the substance of the order is this, Lordship.
Yes, what do you mean by substance, sir? Please, don't go back. Perverse in only new identity, whereas the admittedly is other of Jaipur, is an old functioning in Jaipur, prior to the ban imposed by the.
Lordship, it is admitted that they were running the industry in the name of Sarda Plywood. on the
This
same
is the
place.
finding of your officer that I have visited
They-
the
yes, that
site, it is absolutely new unit, everything is new. How to, what is the material to say that, no, despite that, this report is wrong.
No, that was reviewed by the authority under the act. Lordship, page 27.
Uh.
The Commissioner of Central Excise,
27.
page, I therefore. Page 27.
27, yeah.
I therefore, in exercise of power conferred upon me under subsection 2 of section 35E of Central Excise Act 1944, authorize and direct the Assistant Commissioner Central Excise Tax Division Dibrugarh arising out of so and so to apply to Commissioners Excise Guwahati to correct the determination on the following points. 1. Whether the Assistant Commissioner's order is proper and legal in granting eligibility to Messrs. Sarda Plywood Industry Limited, Jaipur, to avail benefit of exemption in term of notification dated so and so. Whether unit of Sarda Plywood Industry, Jaipur, renovated at the same site and restarted commercial production on 14/10/2009 may be treated as new unit, and whether their eligibility of benefit of exemption under said notification as amended can be allowed considering the new unit. Whether the Commissioner appeal should pass any order may be deemed infringement of.
So,
That was reviewed by the Commissioner.
whatever it may be, you may review and you may observe so many grounds which are not at all tenable. How we are concerned with this? How we are bound?
No, Lordship, I am not saying that the Lordship is bound. But
Then
we are
Why are you
placing,
referring to this?
no, because Lordship,
He may have his idea, own opinion that it can be challenged on these grounds. But the finding of fact remains that it's a new unit.
no, that is
What
held
is
by,
the material to, in contrast to that, sir? That no, it's a new, not a new factory, it's a old unit.
that was
What is the
the,
material? You just show us the material.
but that was the submission of the department before the system.
Submission, you may make plenty of submissions which are not at all relevant. Can be,
In
yeah.
paragraph 3, before the CSAT, we stated. Otherwise, all the authorities is held against the department. Lordship.
We'll dictate the orders, sir.
Lordship.
Close for orders.
Item 28.
Can be taken at 2 p.m. Can be taken at 2 p.m. My lord, Mr. P. Purkais is on legs, my lord.
You can proceed against that for some decision here. But अभी rule 30 का different permission from this program. I have studied that. The department also actively you have to show that the opponent did not take one. But because of this going, then they would say.
That's over the time.
May I please? In this manner, the case already I have annexed in the reply, affidavit page number 96. Page number 96 of the affidavit reply, my lord.
It within reply.
Yeah, page number 96. Honorable single judge has already decided the issue that if someone procures a degree, my lord, in absence of NOC, then he cannot be barred from taking the charge of the principal of the school, my lord. And his degree cannot be held to be invalid. That has been decided in many writ petitions.
Then why this writ petition before the division bench?
Division bench, prior to that, we have filed that, my lord. Subsequently, individual orders have been come. That's why we filed the individual writ petitions before the single bench, my lord.
You have already filed.
Yes, that is the outcome of the, my lord, one of
So
the,
this has become infectious now.
not exactly infructuous. Here we have, my lord, in addition to that, my lord, we have challenged the service rules of 1965. So, because, my lord, they have taken a plea that as because the rule 13 of the 1965 rules prescribes that the NOC is required to be taken. That's why, my lord, they have
So once the court has already interpreted.
yes.
Even though if they without NOC.
Yes,
if
lordship.
a degree is procured or obtained,
Yes.
that will not. affect
Yes, that's why my submission is that, my lord, your lordship may kindly be pleased to, my lord, observe this and may dispose of this.
Once you
What happens is this, he's challenging this repetition is something else and he's arguing something else. What he challenges is the rule which entitles the department to hold an inquiry or hold him guilty of misconduct.
That can be
If he
said to be
takes, no, that the rule is there. The rule
can
is
be
there.
said to be unreasonable.
That is the challenge that he has made in the rule, in the repetition. And if lordship has page 99 of the affidavit in reply, the order of the learned single judge, lordship's order itself, para 9, it says we are entitled to hold an inquiry.
That is perfectly valid.
So his only challenge is that we should not hold an inquiry. His challenge is that the rule should be set aside. That is what he's saying.
That counts.
Otherwise, that the degree is valid, we are not against that. He's
That has
praying,
already been ruled.
Malak,
That this court has already ruled.
yes, that the degree should be valid. There is no difficulty in that. But he says that even the
Where is the rule, rule 13?
Rule is quoted, my lord, at page number 98, my lord.
98.
Yes, in the judgment is quoted.
yes, para 4, he challenges this rule.
What is wrong in that?
But initially we put to challenge that, my lord, in the rule, along with the circular issued by the department, my lord. And after that, when the individual turn has come, individual candidate has been deprived of, my lord, individual, some other persons have been given the charge, that we have put to challenge the single bench writ petition, my lord. And in that, in those writ petitions, the orders have come by this time, the independency of this instant writ petition. And in this writ petition,
So now what do you want? What you want to pursue this petition or not to pursue this petition? Tell us.
my lord, your lordship may dispose of by court by observing
By,
this development.
by way of this petition, the petitioner has essentially challenged the validity of Rule 30 of the Assam Civil
Service bracket conduct.
Assam Civil Service in bracket, Assam Civil Services in bracket conduct rules 1965. Full stop. It is noticed that during the pendency of this writ petition, the petitioner has approached writ court by way of filing writ petition number
My lord, 5419/2023,
5419
2023.
oblique 2023, which was decided by the learned single judge on 18/12/2023. Wherein a grievance was raised that the respondents have illegally not allowing the petitioner to hold the charge of post of principal of a school because he has obtained the BA degree,
Master's degree.
Master degree.
master's degree without obtaining prior permission from the court. Full stop. This court, the learned single judge, while above referred judgment, has disposed of the writ petition, directing the respondent authorities to allow the petitioner to hold the charge of the post of principal of concerned school after due verification of particulars, due verification of the particulars. Full stop. Learned counsel for the petitioner has submitted that since he has already got the required relief before the writ court wide judgment dated 18/12/2023, he is not pressing his challenge to the Rule 13 of the rules of 1965. In view of the above, this writ petition is dismissed as not pressed. Permission from the authorities.
Item 30.
Twenty-nine.
My lord, before my learned friend starts, my lord, may I make a humble submission subject to my lord's pleasure? My lord, the writ petition was filed challenging an interim order, non-consideration, etc., interim order. The learned tribunal thereafter has passed an order considering their application and MA, and my lord, rejected their application. No challenge has been made to that order in the present writ petition. Only a supplementary affidavit has been filed to bring on record that. Now, my lord, in my humble submission, lord, subject to my lord's pleasure, your lordship will kindly consider the question whether an order which has not been challenged in the original writ petition could be challenged by way of a supplementary affidavit without amending the writ petition or filing a fresh writ petition. This is my first humble submission, Lord. Subject to that, Lord, the other aspect is, Lord, that the respondents, the petitioners here, the respondents before the learned tribunal have not filed their opposition to the OA or to the contempt petition. On the last occasion, my lord, as a result, Lord, that OA is not being adjudicated. Now, my lord, the interim order that was passed and which has been continued by rejecting the MA of my learned friend, my lord, that interim order was prima facie on the basis so that the OA is not rendered infructuous. Lordship will kindly consider one thing, Lord.
Just a minute.
My-
Even though if they have filed an MA and that MA has been dismissed, ultimately we have to examine whether the tribunal was justified in passing the interim order or not.
But on different grounds, my lord. Initially one ground, subsequently on their MA, my lord. This is one. The other aspect, my lord, is, my lord, an interim order, as your lordship knows, is for a particular purpose. Now, that if that particular purpose was to see that the balance of convenience, etc., as your lordship knows.
Let him.
No, my lord, one thing, my lord. My lord, suppose your lordship is holding that the interim order is bad. Will the OA survive? Lordship will kindly consider that because, my lord,
Why not?
L. Chandrakumar has said that the learned tribunal would be the first court of adjudication of a matter. Now, if the interim order is considered by your lordship and orders passed, would my OA remain?
Why not?
Lordship will consider that aspect, Lord.
It
Because, my lord, why I am saying this, Lord? Because ultimately, if I succeed in the OA, by that time, much water would have flown down the Ganges.
That is in every case. That is-
Result would be, my lord, that the OA would be rendered infructuous. And now, my lord, they have not wanted it to be adjudicated.
If any interference by this court or any other court would render your OA infructuous, we'll take into consideration this aspect also while passing any order.
Lordship will
Why
do
you
that.
are- why you
I'm grateful, my lord. I'm
anticipating-
very grateful, my lord.
How you are anticipating?
No,
in
because, my lord,
advance that
no,
MA
no,
is
no.
going to
My lord,
interfere
why
in the
I'm saying
matter
this, my lord?
and it would render your.
My lord, with great
application
respect, my lord.
infructuous. That is all.
With great respect, my lord, why I'm saying this, my lord? If the final order in the MA has not been challenged, would it be
Essentially,
rational and justiciable?
consider that aspect also.
Lordship will do. I'm grateful.
That is done.
My lord, if your lordship would kindly come to page 203, my lord. The additional affidavit which we have filed following rejection of our MA, my lord, when we brought on record the order of the tribunal. Please have para 6, my lord. My lord, it's a writ petition, my lord. It's not a suit where all these objections are raised, my lord. It's a writ petition, my lord. Even postcards are also entered in.
They have.
Anyway,
They are raising the
Page
objection.
page
Why are you
203.
worrying about that? It is for
Page
us to
203,
consider
my
and
lord.
decide.
Yes, yes.
Yes.
That the writ petitioners beg to state that writ petitioners have filed the instant writ. Page 203, my lord. The additional affidavit which we file, wherein we have brought on record
Yes.
the, my lord, final order passed in the MA.
Yes.
That the writ petitioners beg to state that the writ petitioners have filed the instant writ petition challenging the legality and validity of the interim order dated 37/24 passed by the learned Central Administrative Tribunal Guwahati bench in OA number so and so. And now the writ petitioners through this affidavit would also like to challenge the judgment and order dated passed in MA dated so and so, dismissing the said MA with a prayer to set aside the said judgment and order dated 1/10/24 dismissing the MA. It is further prayed that by writ petitioner to be treated this affidavit as a part of the present writ petition. So, my lord, in substance, we have brought on record and we have also laid a challenge to the subsequent order which was passed during the pendency of this proceeding. And by order dated, my lord, of when initially we moved this petition, this aspect was made very clear by order dated 6/9/24. Now let us come to the case, my lord. Lordship will kindly have that same pleadings, my lord, at page number 222. It's a simple case, my lord, where the applicant before the tribunal, my lord, he was given a posting order. That posting order was reviewed and that was put to challenge. Now kindly see, my lord, the view of the tribunal. Page 222.
Yes.
We have re-examined the matter
it is a settled position of law that in the context of right flowing under relevant rules, which was sought to be altered with effect from anterior date, and thereby taking away the benefit available under the rule in force at the time, such an amendment having retrospective operation, which has the effect of taking away benefit already available to the employee under the existing rule, is arbitrary, discriminatory, and violative of the rights guaranteed under Article 14 and 16. In the present case, admittedly, the applicant had qualified the selection process pursuant to the notice dated so-and-so in terms of MSRR 2023 and guidelines dated 24/23 for empanelment to the post circulated by BSNL and thereafter empaneled on 1/6/24, which had been acted upon by the issuing posting order dated so-and-so, and the writ petitioner, the respondent petition OA had joined in the promotional post. Well, it was not a case of promotion. The tribunal proceeded that it's a promotion. And my lord, I don't know, where is the question of giving retrospective effect or violation of rules? Whose case was it, my lord? Is it a case of promotion? So tribunal basically proceeded on the basis that a promotion was given to the applicant before the tribunal, and that promotion order could not have been done away with in the manner it has been done. After having been relieved from his previous post of principal chief engineer Senai.
Just, what are the facts?
Yes, now I'll come, my lord. Just I have showed the, my lord, the prima facie erroneous view of the tribunal. Now lordship will kindly come to the writ petition. Now what had happened, my lord? If your lordship should kindly come to page number 182.
Yes.
This was the order, my lord, by which the applicant responded, my lord, when he was working as principal chief engineer Chennai, Tamil Nadu, he was transferred and posted as CGM Any Circle, Dimapur. Page number 182. Kindly see the heading, my lord. Transfer and posting of officers, executive for CGM level regarding. Now, serial number 6, my lord, is the Sashikant, is the applicant before the tribunal. He was principal chief engineer Chennai, Tamil Nadu Circle, and he was posted to, my lord, CGM Any Circle, Dimapur. Now, this order was, my lord, reviewed. If your lordship would kindly come to page number 1, my lord, 184, my lord.
Yes.
DOT-wide ID dated 26/24 has intimated that the empanelment process adopted by BSNL is inviolable for ITS cadre post being operated in BSNL as per cabinet approval, and directed BSNL to comply to its instructions with immediate effect. In pursuance to the above, officers mentioned in Annexure A who have joined as CGM after 26/24 are hereby relieved from the post of CGM with immediate effect and to join their duties as mentioned in the aforesaid annexure. So, my lord, he was sent back. Now, before, my lord, approaching the honorable tribunal, he, my lord, in fact, handed over charge. He, in fact, relinquished his charge. If your lordship would kindly come to page 193. Before approaching the honorable tribunal, he relinquished the charge of the, my lord, CGM Any Circle 2, Dimapur. Kindly see Department of Telecommunication, CGM T BSNL Any Circle 2, Dimapur was relinquished by Shashikant so-and-so on 27/24 afternoon in accordance with BSNL order dated 19/7/24. The order which I have read, my lord, just now. So thereafter, he went to the tribunal, and at page 194, after he relinquished the charge, another officer was given the charge of CGM Dimapur, my lord, at page 194.
194 is the.
Is an order whereby which, my lord, instead of the applicant before the tribunal, this officer Sanjay Kumar, who was given the charge of any circle two. Now, my lord, let us come to the facts and the legal issues involved in this case. Now, if your lordship would kindly come to page 177.
Rules of copy বিলাক separately ready আছে নহয়? দুটা set, চাৰিটা। এতিয়া বাকী কেইখন ন? খালি দেখোন কৈছো তোমাক, নাই নেকি? কোৰ্টৰ কাৰণে দুটা set নালাগে? নাই যেন পাইছো। বাকীখিনিও কিন্তু মই set কৰিব কৈছিলো। এতিয়া সেই ৰোলটো যেতিয়া দেখাম যিহেতু ফটো দিব কাৰণে কপি নাই। চিভিলটো ক'ত আছে? দুটা কপি। কোনে? এইটো পেজটো লোৱা। পেজটো লোৱা। পেজটো লোৱা। চিভিলটো ক'ত? ৰেডি ৰাখা হ'ব।
Yes. Yes. My lord will kindly come to page 177, my lord. This process of empanelment started with this. Because there were errors, the authority reviewed the decision. That's the case, my lord. Now, what is the substantive right? Page 177.
Yeah.
Guidelines for empanelment of officers for holding the post of Chief General Manager in BSNL. Recruitment rules of BSNL Management Service streamwise 2023 has come into operation with effect from 31/12/22. BSNL MSRR, that is Management Services Recruitment Rule Telecom, under Schedule 1 provides that selection of officers for the post of CJM shall be made as per separate executive instructions to be issued with the approval of competent authority. Accordingly, with the approval of the competent authority, criteria for empanelment of officers for holding the post of Chief General Manager in BSNL is prescribed as hereunder. Now, who all are eligible persons? All serving absorbed BSNL recruited principal general manager grade officers, all serving ITS Group A regular HAG and HAG level officers posted in BSNL, all serving senior general manager grade officers of BSNL for empanelment to the post of CGM of a small circle. Now, my lord, there is a little background. What had happened? Sometimes in the past, my lord, a voluntary retirement scheme was introduced in the BSNL. Lakhs of employees, my lord, opted for voluntary retirement. In the post implementation of the voluntary retirement scheme, it so transpired that in some of the streams, there are people in excess of the requirement. So therefore, my lord, they took a policy decision that we'll have to accommodate these people. Now, this decision was taken by way of this letter, my lord. এখন দিয়াচোন কৰক। My lord, আপোনাৰ এটা কপি এটা তেখেতক দিব লাগিছিল, হা? Kindly see, my lord, it's a communication dated 23/11/21. My lord will kindly come to internal page 5 of this document.
This is not part of the records, my lord. With
Hey,
great respect, this is not
Bhagwan.
part of the records.
Please come to E, my lord. The number of GM and above grade executive working in civil, electrical, telecom factory stream are more than the numbers fixed under the post VRS sanction strength. These executives shall be used on the common management posts like HR, administration, SNM, EB, and BA. BA means, my lord, business areas, head, etc. So, my lord, it was found that there were more officers than the strength is. Therefore, my lord, they took a decision that we'll have to accommodate them somewhere. Taking note of all these things, my lord, this page 177 exercise was undertaken. Now, if your lordships will see, there are several streams like telecom stream, civil stream, finance stream, electrical, etc. Now, the original applicant before the tribunal, he belongs to civil stream, my lord. There is a separate recruitment rules for them. We are concerned with telecom stream. For the telecom stream, my lord, the rule is at page number 77 of the OA. Sorry, read petition, 78. If a lordship would kindly come to page 88, my lord. Okay, the strength. Page 88 on top. Authorized strength of the telecom operation stream BSNL management service. The existing authorized, page 88.
88. Random strength.
I'm so sorry, my lord, 80. My lord, I'm sorry, my lord, it is 80. My lord, in my page 88.
80.
Authorized strength of telecom operation stream BSNL management service. The existing authorized strength of telecom operation stream of BSNL management service, which is subject to change as per workload review by manpower plan, are given below. Kindly see, my lord. Chief General Manager, Principal General Manager, there are total 63. 37 CJM and 26 Principal General Manager. So that means in the entire country, my lord, there are 37 circles. And each circle would be headed by a telecom stream person who would be the Chief General Manager. There is no question of, my lord, a civil wing person manning a post of Chief General Manager, telecom. That is the error which has crept in. That's why the authority has reviewed that order. Now, my lord, as far as they are concerned, civil stream, their rule they have annexed in their affidavit at page 273.
Yes.
Lord will kindly come to page 275.
Yes.
Now kindly see, my lord, rule 5 authorized strength. Chief General Manager, Principal General Manager, Principal Chief is their equal, my lord. Kindly see the strength. 5 total, 1 CGM, 4 Principal General Manager. So he can vie only for this. He can vie for a my lord, a CGM's post in the telecom stream. So there is no question of a civil person.
Now, please verify one thing.
Yes, my lord.
In this order that make it whereby you are revoked, na?
Yes. Revocation order is at, my lord, the principal decision is at page number 188.
188.
Yes. That gives the reason, my lord.
No, this is not.
No, this is also one of the order, my lord. I was about to place it.
Maybe
Yes.
We are
Yes.
we are about this 184.
Yes.
Why you mentioned
Yes.
that the already these persons who have already joined.
Join means, my lord, pursuant
Joined
to the,
after 26 are
Yes.
hereby relieved. Why this limited the persons, suppose if ineligible persons
My lord.
who are posted
yes.
joined prior to this 20th of June 2024, they would remain there. And the persons who have joined after that,
No,
they are only.
no, my lord. Pursuant to the decision, only 9 officers were posted, given posting.
Fine.
No, my lord, I'm telling, out of that, 2 did not join. 7 joined. And all have been, my lord, sent back to their original posting. Initially, when the tribunal passed the ad interim order, my
Joined
lord,
after-
at that stage, only petitioner was.
Why you have mentioned this 20th of June 2024? Why this date is mentioned in one page 184?
1 second, my lord. Because, my lord, this order was given effect to. Now, kindly see, my lord, the order by which he was sent.
182.
One second, my lord. Yes, please come to page 182.
Yes.
This is dated 7/6.
Yeah.
Only pursuant to this order, they joined.
Suppose 9 persons have transferred, you said 9, 2 have not joined and 7 have joined.
Yes.
Then why you have mentioned, just for the sake of understanding, why?
Anyway, I'll have that instruction also, my lord. My officers are there.
June 2024.
I'll have that, my lord. I'll answer to that query. Now let us come to the other points. Now, my lord, please come to page 188, why we have to review this decision. The decision which your lordship sees at page 177, this was reviewed. These are the reasons. 526.
Yes.
Kindly see, my lord, the subject review of guidelines for empanelment of officers for holding the post of CJM in BSNL regarding. Guidelines for empanelment of officers for holding the post of Chief General Manager in BSNL were notified to the approval of the Management Committee of BSNL via order dated 24/23, that is at 177. DOT via note dated 26/24 has intimated that said empanel process adopted by BSNL is not tenable for ITS cadre post being operated in BSNL as per the cabinet approval. It was also intimated that sanctity of HSE promotion granted to ITS officers after DPC conducted by UPSC and with the approval of the ACC is inviolable for cadre posts and directed BSNL to comply with its directions conveyed therein with their immediate effect. Now, I may just, my lord, pause here and explain this position. My lord, in the telecom stream, there are 3 types of officers. There are certain officers who belongs to DOT, Department of Telecommunication, Government of India. There are some officers, my lord, who are absorbed in the telecom stream. and there are some officers who were recruited by BSNL from the stage of DGM level. Now, as far as the,
One is absorbed by the DOT.
no, those belonging to there's actually, my lord, they're ITS officers, Indian Technical Service.
Fine.
So telecom service. Then second category is those persons who were absorbed in the BSNL.
Absorbed in the BSNL and earlier they came into.
They were in DOT.
DOT, okay.
And third is, my lord, the officers were directly recruited in the telecom stream from the stage of Deputy General Manager and onwards. So as far as, my lord, these ITS officers are concerned, their service conditions are already governed by statutory rule. So therefore, my lord, they could not have been brought within the purview of the 24-23 notification, because an executive order cannot override the statutory, provision. So these are the infirmities which were there in the, my lord, 24-23, order. That's why, let me read it further. In view of the aforesaid direction of DOT, I'm reading para 3 at page 188. The management committee of the BSNL board has reviewed the above cited empanelment guideline dated 24-23 and have now approved the following. The existing guideline for empanelment of officers for holding the post of Chief General Manager in BSNL issued by BSNL letter dated 24-23 and 26-5-23 stands withdrawn with immediate effect. The existing panel of officers empaneled for holding the post of CJM BSNL stands lapsed with immediate effect. Officers from regular ITS, HAG level ITS officers will be identified and shall be posted as CGM in BSNL, strictly as per direction issued by DOT, white letter dated so and so. The tenure as CGM of the officers appointed through empanelment process will end as soon as now new officers are posted as per the direction dated 26-24. This is the relevance of the date, Miller, because 26-24 was the decision taken by the highest authority of the department. That is the significance of that date. Now, my lord, to cut short the whole thing, this long argument, my lord, the petitioner, original applicant, he belongs to civil stream. There is a set of rules governing his condition of service. He can hold the post of CGM also within that stream, but he cannot hold the post of a CGM in telecom stream. And secondly, my lord, in an executive decision, there could be an error, and power of review is inherent in any executive decision. So that the power has been, that authority has been reviewed and he has been sent back. Now, what is that indefeasible right, my lord, that once he has been given a posting to Dimapur, that has to stand under any circumstance, the authority cannot review it? I fail to see any. And my lord, the tribunal has gone by the view that it was a case of promotion. It's not a promotion. It was a simple case of empanelment for transfer and posting. It's not that they have undergone a promotion process. Now, my lord, kindly come to the rule position also. That also makes the position very clear. If your lordships would kindly come to page 78, the rule. This is the telecom rule at page 84. It's part of the schedule, clause 7, towards the bottom.
Yes.
PGM, CGM, promotion by selection. Selection, executive in senior general manager's grade with 3 years regular service in the grade of GM as on January of the year. Now there's a note, Miller, this is important. Selection of officers for the post of CGM shall be made as per separate executive instructions to be issued with the approval of the competent authority. In terms of this power, my lord, that 24-23 order was issued. But in the process, it is so found that certain, my lord, irregularities crept in the decision-making process, and which now stands corrected. Now, therefore, what is their right? Now, please come to page 85, my lord. Clause 6.
Yes.
last four sentence. CGM, PGM level, page 85 towards the bottom, my lord. CGM, PGM level posts shall be filled up from regular ITS, HAG and HAG level NF IT officers deployed in BSNL who have entered in the 27th year of service as on 1st January of the year circulated from the year following the year of examination, on the basis of which such officers have been recruited in duty. So, my lord, this will govern, this clause will govern the condition of, my lord, ITS officers. So, in the scheme of these rules, my lord, where is the scope of the applicant usurping a post in the telecom stream? Now, my lord, they would like to argue perhaps at page 78, 2.3, at page 278.
Yes.
Common management posts. Common management post of GM level and above of BSNL management service like HR, administration, marketing, sales, enterprise business, etc., where technical expertise is not necessitated by virtue of telecom operations requirement, may be manned by executive at GM level and above with requisite qualification from any stream of management service on merit basis.
I'm grateful to my learned friend. I'm grateful.
You'll have your turn, sir, please.
Lordship.
Yes.
The scope of the common management posts can be expanded as per business requirement of the company with the approval of the management committee of the BSNL board. Now, my lord, what meaning does it carry? Let us try to understand this. I know they're in their affidavit in opposition, my lord, they're banking on this. My lord, kindly see, I'm reading it again. Common management post of GM level and above of BSNL management service like HR, administration, marketing, sales, etc., where technical expertise is not necessitated by virtue of the telecom operation requirement. Now, my lord, the telecom stream is a stream where technical requirement is very much a necessity. It cannot be manned by X, Y, and Z. A civil engineer, he cannot, man a position in the telecom stream. My lord, end of the day, in the exigencies of the service, many actions can be taken. Does any enforceable right flow from that? In a given situation, in an emergency, my lord, in exigencies of service, so many things are being done. But that will not bestow any enforceable right. You are a civil man. What is your right to hold a post in telecom stream? So, my lord, this only throws light to the extent that where technical expertise is not required, then GM level and above posts can be made by people from other stream, provided technical requirement is not there. What is going on?
Yes.
So therefore, my lord, to sum up my argument subject to what my learned friends say, that say in my reply, the 24-23 empanelment process was wrong because it tried to tinker with the rights of ITS officers. It purported to include officers from other stream who are otherwise not eligible. Therefore, that decision was reviewed, and eventually 26-23 was 24 was the date when the decision was taken. Therefore, my lord, these orders have been made effective from 26-24, and the applicant, my lord, pursuant to that 19/7/23 order, he in fact relinquished his charge. Thereafter, he approached the Honorable Tribunal. Initially, Tribunal passed an interim order primarily on the ground that there were 8 other officers. How come you have picked up this person only? Since the process was started with the applicant, my lord, it took some time. Eventually, by now, all the 7, my lord, have been not repatriated, they have been sent back. Repatriation is a term which has its own legal connotation, my lord. used in the context of when we say a person is deputed. He was sent on posting and the posting order has been cancelled, the consequence of which is went back to his original position. And he is a person from the civil stream, he cannot hold a post in a telecom stream because the cadre strength is 37. These 37 circles are to be manned by telecom stream person, not by a civil person. Yes, within their sphere of, career advancement, there are 1 post of CGM and 5 posts of principal chief engineer that they can, to which he has a right. Now, that being the position, my lord, tribunal has heard. Now, where is the question of issue of promotion? Where is the question of retrospectivity? I think tribunal has wrongly evaluated the facts, my lord. So that being the position, my lord, there is nothing in this case before the tribunal. Lordships will vacate this order, my lord. And my lord, let the OA be heard in its own turn. To that we have no difficulty. Reply put in the file. No, do you think we can have Yes, madam. Yes. 182, my lord. Yes.
You have said all these 9 officers are not from the telecom.
Yes, my lord.
All these 9 officers are not from the telecom field, so they have been repatriated.
No, one of them is from telecom, my lord.
Then which is
He has been retained. He has been retained. No?
Which is.
1 second, my lord. ये तो था को भी वापस किया बिकॉज नोट 6 में नहीं आ रहे थे तो नोट 6 में नहीं आ रहे हैं yes I followed him my lord yes in respect of this gentleman called Vanavatu Venkatasarelu he is actually my lord CGM Tamil Nadu Circle my lord he has also been brought back because he does not come within the habitat of the note 6. Note 6 at page number. Yes, my lord. If your lordship kindly comes to last 4 sentence. Essentially, these are posts for ITS officers, my lord. So he's not an ITS officer. Oh, ITS? Junior senior. And plus, my lord, in the seniority list also, his name was down below. 7 क्या हुआ? He has been retained, my lord. Because of the seniority part, he has been retained. He's an ITS officer.
But he is not an ITS officer. Oh, that's
ITS.
Yes.
My learned friend has made out a case that is a case of transfer, not promotion and transfer, and therefore we have just sent him back. But it is a case of promotion and reversion. The learned tribunal has examined this issue and it is there on the records, but I take your lordship first to page 78, Lord. The recruitment rules of BSNL Management Services Telecom Operations Stream 2023 of 31st December 2022. Lord, there are different rules, but this rule has got a specific connotation because of 2.3, which my learned friend was placing before my lord. Lord, kindly comes to 2.3, common management posts. The common management post of GM level and above of BSNL management services like HR, administration, marketing, sales, EB, etc., where technical expertise is not necessitated by virtue of telecom operations requirement, may be manned by executives at GM level and above with requisite qualifications from any stream. I am placing emphasis on this, my lord, any stream of management services on merit basis. The scope of the common management posts can be expanded, so on. I'm not on that. Now, my lord, kindly comes to right-hand side, page 79, 4. All the services, say various existing cadres comprising of telecom operations, finance, etc., shall be known as BSNL management services. Now, lordship kindly comes to the schedule. It starts at page 83, Lord. Method of recruitment, promotion to higher grade of telecom operations stream of BSNL. Now, lordship kindly comes straight away to the relevant portion at page 84, serial number 7. PGM oblique CGM E9 level. Number of posts 63. 37 CGM plus 26 PGM. Post-based. Promotion by selection. Selection. Executives in senior general manager's grade with 3 years of regular service in the grade of GM as on 1st of January of the vacancy year. Note, selection of officers for the post of CGM shall be made as per separate executive instructions to be issued with the approval of the competent authority. Now, Lord, kindly comes to the relevant page, the instructions, guidelines at page 93. Document dated 24/2023. On the right-hand side top, it will get visible. Age criteria, at least 2 years of service left as on the date of notification. Then eligibility. All serving absorbed oblique BSNL recruited PGM grade officers. All serving, the rest are not relevant. Only this one, Lord, because the applicant comes within the respondent here. Then work experience, etc. is there. And my lord, lordship will look at psychometric test. Psychometric test by a professional consultant external agency using modern tools to judge management leadership qualities. Now, lordship kindly comes to the selection committee for impanelment of officers for the post of CGM BSNL shall comprise of CMD, Director HR, and 2 directors nominated by CMD. Now, lordship kindly comes to page 170. This page will refute what my learned friend was saying, that it is not a promotion. Lordship kindly comes to the page at the top right-hand side, your Lordship will see the date, page 170, my lord. Promotion of I'm sorry, 170, my lord. Lordship sees the heading, subjectives promotion of executives of civil stream to PGM on regular basis. Approval of the competent authority is hereby conveyed for regular promotion of the following executives of GMs, senior GM level of civil stream to PGM on as is where is basis in accordance with BSNL MSR 2009 with effect from the date of assumption of the charge of promoted post and until further orders. Here the name of the respondent number 1 is at serial number 3. ठीक है उसके बाद
Impanelment, here it is closing that we are PGM.
हाँ PGM उसके बाद PGM 101 हाँ नहीं वो नहीं 101 दिखाते थे
Anyway, it was PGM over there.
Now,
number
just at the time of your this so-called promotion, which you are claiming that you have been promoted.
no I have not shown page 101 Miller.
Just a minute, sir. Please let us know. At the time of this passing of the order of 7th of June, or what is the date of that order?
Yes, Miller.
7th of June 2024,
Yes,
you were working as
PGM.
PGM. And PGM and the
CGM,
CGM are the equivalent posts.
No, see, Miller,
PGM and CGM are the equivalent.
no, we are CGM. I am holding CGM, Miller. On the date on which reversion has been made, that
Not
is
reversion, sir.
Huh.
You were holding the charge of the PGM.
of
and
CGM.
CGM.
CGM, Miller. Page 74, the name.
It's right, sir. 7/6/2000, prior to 7/6/2024,
Yes.
you were working on which post?
Principal Chief Engineer, Tamil Nadu.
Principal Chief Engineer, Tamil Nadu.
Which is equivalent to
It is a PGM post.
It's a PGM post. So
Yes.
PGM, you were already working on PGM.
Yes.
Now, why this order dated 7/6/2024, you are promoted to which post?
To CGM.
CGM is not a promotional
Yes,
post.
yes, yes.
No, it is not, sir.
Yes, Miller.
It is not a promotional post.
Lordship will kindly come to page 101.
101, come.
Miller, document. एक मिनट just
It's an empanelment. It's not a promotion.
which one? 83 में तो 7 नहीं हाँ,
Yes.
My lord, page 101 Miller.
Yeah.
Subject, my lord, second round 16/2024 document, my lord.
Yeah.
Subject, second round impanelment of executives, officers or holding the post of chief general
So
manager.
holding the post of chief general manager doesn't mean promoting to the post of chief general manager, sir.
It is, my lord, lordship kindly comes to page 84, page 84, my lord. This is by way of selection. Page 84, my lord, serial number 7.
Yes.
PGM/CGM and promotion by selection. by way of an empanelment through a selection process. And the note of 7 says, selection of officers for the post of CGM shall be made as per separate executive instructions to be issued with the approval of the competent authority. Both PGM and CGM
Now you have tried, you now try to build your case as a case of promotion. Now come to page 195.
195.
This is your representation. Here, nowhere you said that I have been promoted and posted at so and so place. You have simply said, please post me not in Dimapur, please post me somewhere else. You yourself were saying, requesting that don't post me in Dimapur. It's so
195.
dangerous place.
Milord, let me tell you, Lordship.
You should just first
Milord,
go through it.
Milord,
You
that's
just go through it. Sir.
Milord, I've seen that. Milord, may I say this, Milord? If I have not been able to demonstrate that CGM is a promotional post, kindly tell me.
Yeah, you have not been able to demonstrate.
I'll
that
show it again.
CGM is a promotional. Yes.
Milord,
To be very frank.
that's why, Milord,
To be very
now, Milord, kindly comes to 84 again. Now, 84, Milord, bottom contains a note. Note.
Yeah.
Selection of officers for the post of CGM shall be made as per separate instructions to be issued with the approval of the competent authority. Now, kindly comes to, so Milord, with great respect, Milord, if I'm wrong, kindly tell me. Selection. First of all, Milord, the entire thing is promotion. Milord, kindly comes to page 93 now. Relevant for that note, Milord.
Yeah.
Milord, kindly sees the guidelines, subject. Guidelines. Lordship has got it, Milord. Guidelines for empanelment of officers for holding the post of Chief General Manager. Milord, before that, Milord, may I say this, Milord, that language, holding post, etc., Milord, it depends upon who is drafting it. Your Lordship will draft a judgment in a particular manner, another honorable judge will draft. So that's of no consequence. Now kindly sees.
Clarify for our understanding.
Lordship.
We can come back to 84.
84. Yes, Lord.
84. PGM, CGM has been shown together.
Oblique.
Together, oblique means together.
What is the scale of pay? What is the
Same scale. Pay scale is same. Milord, even then, Milord, your Lordship knows it happens.
Then you have to 93.
93. Yes.
Right?
Yes, 93.
In terms of under
Yes.
84,
Yes, Milord.
this is the policy. This policy you have come in because you are an absorbed BSNL, recruited PGM,
Grade officer.
right? Then
My lord,
we'll have to write that. So let us get us on back.
Lordship.
So then the matter goes up to the government. The government comes back, and tells the, that see, you could not have filled up this post other than people from ITS, HAG, ITS. Right? They take a corrective action. And you are wrong. Now, if you come back, now you can clarify one thing. The post of CGM at Imam, whether it is a post requiring telecom experience.
Yes.
Or not, or not.
My lord,
No,
let me tell you, Lord, that they will be telling. I'll also tell from my client, my lord. But my lord, one thing. My lord, kindly seize page 93 once again, just for my satisfaction, my lord. Your lordship will definitely be faster than me, but then the recruitment.
Yeah.
The recruitment rules of BSNL management services streamwise have come into operation. BSNL MSSR telecom operation stream under Schedule 1 provides that selection of officers for the post of CGM shall be made as per separate executive instructions to be issued with the approval of the competent authority. Accordingly, with the approval of the competent authority, criteria for impanelment of officers for holding the post of Chief General Manager in BSNL is prescribed as under.
That is, they have already, these criteria, they have, with the approval of, they implemented.
Yes.
Now the government has objected to it, that this criteria is not correct. Now they have corrected it.
My lord,
So
with,
what's wrong in that?
My lord.
Whether they don't have any power to correct it?
my lord, this is a statutory rule. My learned friend at the onset said a statutory rule cannot be tinkered with an executive instruction.
Where have it done? It was sought to be done by 24, it's been corrected. Next.
Now, my lord,
Yeah.
so the question is, my lord, that is under consideration by the learned tribunal.
Right.
If it is under consideration before the learned tribunal, where they have failed to file their written submission, reply within the time frame that is prescribed.
File or have not filed?
They have not filed.
Not filed, failed to file means opportunity was given and last opportunity.
In that case, my lord, let it be expedited, but the interim order, my lord, your lordship will have to consider that. Because otherwise, my lord, what happens is, I'll tell your lordship, suppose.
We are giving you a proposal, if you are agreeing to it, we are giving you a proposal.
My lord, before that, my lord, kindly don't express your lordship's mind. Let me just tell your lordship one thing and then I'll hear your lordship. My lord, what I'm submitting is, suppose your lordship is allowing their application and saying that the interim order is to be vacated. What happens? I have to go back to Chennai.
Yes, sir.
In my lower post, number one.
Oh, no.
Lower post, definitely lower post. That is number one. And I have to report to CGM, the Chief General Manager there. This is one. The second thing is, my lord, if the interim order is vacated, lordship will kindly consider this. If the interim order is vacated, what happens to the OA? Does it subsist? Now, my lord, L. Chandra Kumar says, lord, with great respect, lord, your lordship knows L. Chandra Kumar. It must be like the back of your lordship's hand. But I'll just read one paragraph of L. Chandra Kumar, lord. It is from paragraph 93.
Telecom requirement.
Yes.
But I'll just read that part. We may add that the tribunals will, however, continue to act as the only courts of first instance in respect of the areas of law for which they have been constituted. By this, we mean that it will not be open for litigants to directly approach the high courts, even in cases when they question the vires, etc. Now, my lord, so adjudication of service matters is by the learned tribunal.
Fine.
they are adjudicating it. Now, my lord, your lordship will.
Some other observations of the L. Kumar, I think you also gone through it. That despite that, the High Court has power to.
100%. But, my lord,
Despite all
if-
this, the High Court has power to judicial.
High Court under Article 226, sky is the limit, my lord. I know that. But the question is not that. Question is, my lord, once a service matter is to be adjudicated, the tribunal is considering the matter. It's not that the tribunal is not considering the matter. It has considered and rejected their MA. The main matter is pending. Now, my lord, I am down before my lord. Lordship will say.
Now, you have, we are giving you an option. Since you are going to retire in January 2026. That's what we have gathered from your record. You please tell your advocate. Tell your advocate. January 2026, you are going to retire? Yes. Okay. Now, in your representation, you requested them to post in 3 of the places. Bihar, Rajasthan and Jharkhand. You can very well ask these persons to post you in one of that place up to your retirement.
But as CGM.
My request is for CGM. Now, just a minute, see to it. See, come to your representation now. Come to your representation. Page number 195 and read the whole representation. Where you have requested that please post me as a promoter on the promotional post. Where you have mentioned. You read, sir. Please. First you read.
Before I'm reading, my lord. I'm reading.
First
But
you read.
10/6/2024, my lord. This is the date when the representation was made. I was there, CGM.
10/6/2024, immediately after your transfer.
No.
Yes, 7/6.
After impanelment, no.
Sir, yeah, please transfer and posting order dated 7/6/2024, subject reference.
My lord,
195.
19/7 I have been thrown out.
Sir, please, 195, your representation, is it not your representation?
Yes, definitely, but it's on
Then-
10/6/24.
Then read, sir, please. First of all, and the chairman and managing director, BSNL, New Delhi, request for revision of my CGM posting order in North East Second Circle, reference BSNL transfer and posting order dated 7/6/2024. Now read all this.
My lord, I'll show you. CGM is there.
If you are not going to, please
My lord,
read. First
why
you
should I
read.
not read, my lord, when your lordship?
Read first this.
Yes, my lord.
Read your
At
representation.
the outset, I convey my sincere gratitude for having the trust and faith in my leadership and impaneling me for the post of CGMT in BSNL.
That's all.
Then, my lord, wide above cited reference posting orders were issued in which I have been posted at CGM NE2 circle at Dimapur. My lord, CGM.
Read.
I'm reading.
Yes, no doubt.
Hmm.
They have assigned you the posting of CGM.
Yes.
There is a question of promotion. We are just trying to understand.
In this regard, I beg to submit the following few points for your kind and favorable consideration. I was recruited as AEC, working as PC at Chennai since May and got my promotion as regular PGM in the year 2022. I requested my transfer in northern states, etc. Then I'll go to straight, my lord, to the relevant page, paragraph.
Now, come to this paragraph 7. Paragraph 7.
Yes, before that, my lord, just give me a.
This you have, what you have emphasized on your the achievements which you have.
Yes, then, my lord, since my remaining service length is less than 2 years, I'll have no opportunity to serve near my native place if I am posted at Dimapur. I am not fortunate like other impanel officers who have got longer service length are in a position to avail the facility of getting posted back to their choice place after completing 1.5 years of tenure period at Dimapur. My initial appointment letter was issued at Patna. That I had demonstrated excellent manner, etc. Then, my lord, paragraph 10.
Yeah, read.
It is learned that.
Thereafter, I never worked in my home state of Bihar.
Yes.
Yes.
Then, my lord, paragraph 10.
Yeah.
It is learnt that CGM post of Bihar
No,
and
no. First nine.
9.
Read
That I
nine.
had demonstrated external managerial and driving skills and improved revenue network and sales parameter while holding the additional charge of 3G BA in a very short span of 6 months. And I'm capable and eligible as regular PGM to shoulder the responsibility of circle head of if for even larger circles if given an opportunity. Then, my lord, it is learned that CGM. My lord, I
तो सिंपली सेड कि सीजीएम पोस्ट भी खाली है वहां पे भी दे दो नहीं तो पीजीएम कहीं लगा दो आई एम सेटिस्फाइड
my lord, your lordship is holding that CGM is not a promotional post.
यस पीजीएम एंड सीजीएम आर द इक्विवेलेंट पोस्ट
Yes.
Just because the scale is same.
So or what's the difference?
No, my lord, your lordship knows forest, head of forest force and the PCCF, they are having the same pay scale. No change, no difference.
So show us from this
And
representation.
selection process.
Show us
My lord,
you are from a representation that I have been promoted.
their writ petition has documents which show that the post of CGM is a promotion.
What option we have given? If you are ready to, it's okay. Then we'll ask them
Yes.
whether you are ready to be posted.
My lord, I bow down to your lordship, but only with the prayer that it should be a CGM, the post I am holding.
That can't be done. What you have prayed in your representation, will ask them to either.
My lord, that is a circle head.
So PGM to shoulder the responsible of circle head of every larger
Circle head means CGM, my lord.
Whatever it may be, what you have mentioned in your representation, we are looking from that, sir.
My lord, your lordship
We are
will not
referring
look
from
at
that.
the statutory document to show that I have been
Then we'll
demoted.
Consider, sir. You are not, this option is not accepted to you.
My lord,
This option is not accepted to you.
can I say so? Can I
You have
say
said
so?
it, sir.
No,
You have
what
said
I am
it in
saying
so
is
many
not
words.
as I am posted as CGM, I should be posted as CGM. With that, my lord,
Anything else?
my lord, only thing, there were 87 who participated in the selection process.
Sir, this option is not acceptable to you.
Lordship will give me a minute.
And we'll ask them, request them to post in Bihar, your state, home state itself.
No. My lord, I'm sorry, my lord, I cannot. No.
Deeply obliged.
I'm grateful.
Pass over meter 1.
Before your lordship takes up the other matter, there is a hearing matter I'll not do today. Last night.
Yes.
Yes, sir, we have taken step on 7/6/2024, my lord, height, acknowledgement 146783. Order was passed on 6/6/2024, my lord.
5/6/2024, we have ordered, but this Lauzima court, 30th of September 2024 says something else.
Yes. Yes, sir, Lozima, as we didn't take as per Lozima, but the court, as per court order, my lord, we have to taken step on 7/6, my lord.
But where you have not supplied the correct and
Correct,
taken address.
yes.
Then by filing will be dismissed without reference in the, what else?
Yes, ma'am. Yes. My lord, at the time. Age is my lord. As per OA, my lord, OA is with me. As per OA, he said. Yes, that is not here.
The Lazima Court on 8/8/2024 issued a direction to the petitioner to furnish the present address of the respondent. However, the same has not been furnished by the petitioner till date. Full stop. Taking note of the above fact, the Lazima Court has ordered for listing of the matter before this court. Learned counsel appearing for the petitioner raised for and granted. Yes, how much time?
1 week, my lord.
Only 1 week.
1 week, yes, ma'am, I'll collect the,
Corrected address.
yes, my lord.
Raised for and granted 10 days time to furnish the correct address of the respondent. On furnishing the same, let notice be issued to the respondent. The through registered AD as well as Dusty for service upon the respondent returnable on so and so, so and so. 6 weeks, returnable 6 weeks thereafter. Yes.
Must be.
Yes. कुछ रही है ये? Yes.
The next item, my lord, I'm waiting for item number 31.
31. Who is for the other side?
Mr. K.N. Sodri side.
Yeah.
Senior counsel K.N. Sodri side.
So he made a mention about some hearing, my lord. I did not know that this is about my case, my lord. I am waiting here all through, my lord. Your lordship must have seen.
But he, in your presence, he asked hearing matters.
No, my lord, I also have been informed, my lord. This is not fair. This is not fair.
Next week.
No, my lord, let it be in January, my lord. Let it be in January, my lord. It is for, as per his convenience, he, my lord, rises and goes. This is not fair, my lord.
We are not aware that you are for that other side.
My lord, I'm the appellant.
Normal sense, he asked, sir, please, I'm not available. on
Fine, that was fine, my lord. A word ought to have been, my lord, there with me also that I'm not doing the case today. It's fine.
Yes.
Let it be in December, my.
Can it be in November, my lord?
Why, my lord?
Because
If
my
they
lord-
have got the urgency, then why did they not attend that?
Because my lord, I got the
Let it be in
appointment, my lord,
December.
subsequently that has cancelled, my lord.
Let it be in December. This is not fair.
My lord, can it be after 2 weeks, my lord?
January. In the year. Yes.
Item 32.
May please, your lordship. Lordship, before my understanding of that, my lord, in this matter, we need some time to file an affidavit from the government side.
One affidavit has been filed.
32, my lord.
Again,
After three,
affidavit has already been filed.
by the director, but government affidavit is necessary, my lord. In this matter, learned AG will appear, my lord. So one affidavit from the government is required, my lord.
Your lordship fix a date only, nothing.
2 weeks back.
Date may kindly.
The rest of the matters we will take.
Deep your blame.
Yes.